I have a effective today.
What do you want?
Next week.
The request for the learned counsel for the petitioner appellant matters can be drawn to the district. One.
Item number 33. I have filed an affidavit which is not on record. I permitted to bring it on record today.
You have filed a
Affidavit. I am for the respondent. Like,
Item number 7. After
after we.
Item number 42, madam. Recommendation item number 8. My senior Mr. Andori is supposed to argue that his elder brother expired, so that it could not come. In the question.
After
In the
I'd like to mention item 4. We have filed an affidavit yesterday that may be possible.
supplementary item 47 at 10:30 AM.
yes, I have asked both of you to be here present for the purpose of only one thing. Yes, yeah. The thing is like this. This is a woman who is around 84 years old. Can you hear me? The officers, can you hear me? Mr. Director of Pension, can you hear me?
Oh, yes. My lord, I am here, sir. My lord.
Can you hear me?
Yes. My lord, I am here, my lord.
You can hear me?
Yeah,
And,
yeah.
and the Director of Education, Borolan, can you hear me? Can you hear me? Okay. Now you see why I have fixed the matter today. This is a woman who is around 84 years old. She has been trying her best to get her pension. Now, every time what is happening is that the papers are being sent by the Director of Education, Borolan, to either first to the Director of Education, then to the Director of Pensions, everybody it is being sent. And every time it is just getting delayed because of something or the other has not been done. Now you see, on 6/3/2025, I made it very clear that the attempt should be made by the officers so that this woman can get her pension. So my only thing is, I'm fixing this matter again on 25th of April. Kindly, both of you, take your whatever is required, do it and see to it that the pension aspect is being cleared and done. Done?
Yesterday, evening got it trial.
Now the payment will go to her bank account. And I think she must have been given, she must have also provided the bank account.
Already been, I think already been provided. He has to put a deadline. He has verified.
She will appear. Taking into account this aspect, I post this matter again on 24th. You inform me as to whether she has got it or not.
I don't. Yes.
Mr. So-and-so, the Director of Pension, as well as Mr. So-and-so, the Director of Education, Boroland Territorial Council, are present pursuant to the video conferencing mode pursuant to the order passed by this court on 27/3/2025. Mr. J. Hendik, the learned counsel appearing on behalf of the Director of Pension, has placed before this court an order being passed to that effect on 27/3/2025 itself, whereby the Treasury Officer, Kokraja Treasury, have been directed for payment of pension as well as other details for pension as well as for the payment of pension to the petitioner. The said communication is kept on record and marked with the letter C. List this matter again on 24th of April, 25th of April 2025 at 10:30 a.m. Amicus Curie as well as Mr. DJ Didas as Upaidya shall apprise this court as to whether the petitioner have received the amounts in her bank account. This court dispenses with the appearance of Mr. So-and-so, the learned, the so-and-so as well as the Director of Pension as well as so-and-so, the Director of Education, Boroland Territorial Council. Okay, thank you.
Thank you, sir. Thank you.
Thank you, sir. Thank you, sir.
At last, Mr. Das, something has happened good in the morning.
That's true.
Item
One
49.
stroke.
Huh?
There was requirement of only one stroke below. Otherwise, for last 6 months, this lady was languishing like anything.
Not 6 months.
But
This is not a 6 months case.
18,
Right.
almost.
Have you seen what was the case about? No.
I have seen.
She was, her son got lost.
Yes.
She asked for this 2 lakh rupees, which is normally being given to all affected persons.
Government did not give it.
Government, initially the Boroland Territorial Council has forwarded it to be given.
Yes.
The government did not give it.
Yes.
Then the government, and then the matter, first time round of litigation is over. The second time when it came, then I asked Mr. R. Pujari why. Then he said that he
Not
was a
applicable.
teacher and as such would be entitled to pension and all benefits.
Yes.
So did you give the pension? Pension has not been given. Then it was moving this way, that way, this way, that way, this way. The secondary education, the director of education later on first says that okay, it will be given. Then he says that no, they have to then apply this way, and all. This has therefore taken 6 or 7 months to get plus
Very unfortunate,
before something happens to get.
very, very
So
sad.
find out as regards the there will be areas.
Yes, my lord, I have, yes,
There will be areas out.
highly agree.
Item 49, fixed at 10:30 AM.
Where's your friend?
Other side. Available.
Huh?
I have not seen them. I have not seen.
You see, there seems to be two mistakes committed. The learned trial court did not consider that there was a mistake made by the council. And secondly, the provision of order 8 of rule 6G was 6A was not taken in the proper manner, which stipulates that 6A4 was not taken in a proper manner. Though on that day I dismissed this petition, but later on at the time of signing, I thought this aspect was not taken. But on the other hand, there is also some laches on the part as you have not taken any action against the lawyer. So what do you say?
That is admittedly, Lordship, I have called this here, Lordship. After the opportunity was declined, then he filed petition for
So
dispute
it
and
was actually brought to the notice of the plaintiff only in the month of February.
yes,
So the lawyer was at fault, but what action have you taken against the lawyer? What action?
he cannot say.
It is still appearing on your behalf.
Yes.
Then? We refer the lawyer to the bar council. Because something has to be done. I allow your petition, but I refer the lawyer to the bar council. Well, issue
Okay, with
notice,
some
let me issue notice to the lawyer. Let him be present in court.
As per my instruction, the council who is conducting, he was in out of station and his junior was filing this petition.
Whatever may be, it is his responsibility, as he has not. So there were how many persons who signed the wakalatnama?
One.
No, there. How many persons were there who have signed the wakalatnama on behalf of the lawyer?
No idea. Good three.
Huh?
Good three advocates are there.
Get hold of the names. We put everybody out there to the bar council. Because this is absolute negligence. If we don't take action against this type of lawyers, every time this court's time has been spoiled.
With some cost recover from the council.
Huh?
Cost also. Some cost may be imposed.
No. We also ask the court to refer it then to the bar council, the action of the lawyer. And also the bar council to initiate proceedings against. Then he will realize these lawyers.
As per my instruction, he is doing the case pro bono. That
Who?
lawyer Lordship, who is
So then it
conducting.
becomes more, that must be the reason why it must have happened. He was doing pro bono on your behalf, but he was doing better things for the other side, which makes his conduct more worse. There's no pro bono in this type of litigations.
The lady is very poor, therefore
Who is the lady poor?
It's petitioner.
So therefore, the lady should immediately take action. For her behalf, I will take action. Who is the lawyer?
Lawyer looks. Pranesh Roy looks, has filed a petition.
Hmm?
Page number 100 looks.
Ramesh Roy.
File bill.
Because this is a case where quick action has to be taken against the lawyer. I allow the suit to proceed, but I will keep this matter pending till the lawyer is brought to the, will make him a party.
As per order, the council, he was out of India, Kyrgyzstan.
Oh,
The council, the main council, he was in Kyrgyzstan. As per the order, she lordship, the
where was he?
Kyrgyzstan
For how long?
for around 1 month. Right. Because in one order that is reflected lordship.
Where?
Page number 106 lordship.
Yes. So let us ask him. If he is going to Kyrgyzstan, that means he has good resources. Let us take him. These people should not be allowed to practice law. Because without referring, without calling him for me to make a reference would not be proper.
Some cost may be imposed lordship as a compensatory cost lordship.
No. We have to take action against the lawyer. You say that this lady is poor. So the lawyer should pay the 25,000. Then, well, you pay, I'll direct the lawyer, but without the lawyer, I can't say so. Huh? And then we refer the lawyer to the bar council. This type of lawyer business has to be. This is absolutely. He encourages type of lawyers. One has to take that. And who is this? Gitanjali Ihengya. There is another lawyer.
There is another law.
We'll take it up again at 2. Find out the name of the lawyer. And give me, along with the enrollment numbers. Take it up at the cases where strict action has to be taken. And Mr. Deka, kindly inform your counterpart.
For admission item 1 and 2.
Yes, what is this?
My lord, this is against the, my lord, rejection of my application for condemnation by learned member of motor vehicle tribunal. And
Yes, Mr.
opposite
Sakya,
parties,
Mr. Kunta.
Lordship, there in this, on this issue, there is a new development in, before the honorable apex court members. There is an order, my lord, I am placing it. Convention.
Understood. But the problem arises, when will this matter be solved? Not tomorrow. Why am the problem which I feel? If I don't allow them, like Justice Robin Pukan's order, if I allow him in similar manner like that order, then in that case, what is good for you also is the proceeding will go on in that manner. Now, if the proceeding goes ahead, then whatever it is, but at the end of the day, if I again do this, then how do you take care of the interest? Because if I revert it back, then what will happen? Tomorrow, the Supreme Court says if it is taken away, it will be taken away retrospectively or whatever it may be. If it is taken away, then what happens?
That case, Lordship, it is, we have to KD burden, Lordship.
And it will be taken away retrospectively, because this is what they are thinking.
Might be, might be.
So then, wouldn't that be a cause of major problem for the insurance company? Already the matter is delayed.
So there my big point is that, my lord, application of the payment is not barred. Only point is that the limitation part, because under section 164 and 166, there has been barred as per the government of judgment authority. So the under rule 150A of the motor vehicle rules, my lord, they can again go for compensation, because that will be a case based on police report. Otherwise, those cases are private cases, my lord, as done by the honorable apex court in the government of judgment.
But if the police has not given, has the police filed a DAR? No,
In most of the cases, well, this is the problem, my lord.
they are not doing.
They are not
No, that is why the problem, why they had made 166(3). On the basis that now they think that the central motor vehicle rules, that rule 150 and the chapter 13 will be followed. But this is not being followed. And if you are not following it, how will you taking away the rights? That is the reason why it was removed, because it is not necessary. If you have filed it, and that the judgment, there is one judgment of the Supreme Court, no, wherein says that if within a case, that tomorrow if it happens that there is already a DAR file and there is a claim petition file, whichever the claim petition, DAR will be sent to the claim petition place.
should be tagged.
So it is therefore, if there is an accident, there is a mandatory duty on the part of the authorities to do it. Whether the claimant asks for or not, or that is immaterial. But if that duty is not being performed, can you therefore deprive the claimant?
Absolutely not. But my lordship, again, lordship, I am submitting lordship. The way is available for the claimant. I mean, the police people.
Understood. How will the police do it? Tell me. The police is not acting. Is he going to file another petition for that? How much trouble are you going to give it to the claimant?
That is it.
The basic idea, therefore, is there. Not being followed. So how do you defer it? So can't I pass an order to the fair? If in a case where there is no DAR submitted or R submitted to the fair, then the limitation under 166(3) can be held to be only directly. Because here the FIR has been filed.
Yes, sir. FIR
Then also they are not doing any action. Is a state a party? No, na? Hello, let me come back and then we decide this. It's a matter of importance. I think my primary opinion is if you are not following that principle, which is there in chapter 13, then 166(3) will only be directly. It cannot be, you cannot say that the period of limitation is taking into account the intention of the legislature was that. It is why it was removed. It was given effect only on account of that.
I may be wrong, Lordship, but my understanding is that whatever has been there in the LMU and take, Lordship, that provision, limitation provision started with no minor. I mean, the provision manual was 66(3). Now the question of applicability of section 5 of the Limitation Act, Lordship. My humble understanding, matter. States that no application for compensation shall be entertained unless it is made within 6 months of the occurrence of the accident.
6 months of the
6 months of the occurrence of the accident. So there is no scope for interpretation that limitation will apply. It's just started with word no.
And what do you say about section 29(1) of the Limitation Act?
That is there. Yes, sir.
Look, what do you say? 29(1)?
Yes, sir. That is there, but I thought what the limitation was like.
29(1) say, in a case where there is a limitation prescribed from that what is prescribed in the act, in the Limitation Act, there is a separate limitation prescribed in the act, especially. Then notwithstanding anything, the provisions of 5 to 4 to 15, 4 to 20, 4 to 15 would apply. Then in that case, why not a section 5? Because after all, the MSC is the court.
It's an application. Claim application. It's in a claim application. Like what application is there?
It's a court. So why not a section 5 will apply? The section 3 says, section 5 says, an application. This section 5, it says in respect to an application or an application. It means not in a suit. In a suit, section 5 does not apply. But in an appeal or an application, section 5 will apply. And if they can show good cause, why not? We'll hear to this aspect, the important aspect, and I think something has to be done. Now, if therefore you cannot say, because all along the Supreme Court has been holding out there is no limitation prescribed. But there has to be some explanation if there is a delay. And if there is an accident record on it, yes, I'm also of the opinion that too much of a delay. Then in that regard, the court has to reject it to that extent because you may lose the fine. The insurance company would not have any records. Nothing is there, so they may get a clean sweep on that. So you cannot have a proper defense. Or that the driver owner, it will be untraceable. So too much of a delay is also bad. But how do you meet them in between? think something has to work out. Because you see the judgment of the Supreme Court in the case of Union Territory of Ladakh, Kashmir and Ladakh, J&K and Ladakh versus national conflicts. The Supreme Court says that merely because the matter is pending before the Supreme Court, in a reference, review or anything, that cannot stop the High Courts from exercising their jurisdiction. And more so, if this happens after, if they don't do it retrospectively, or if they do it because they may have to take away 166(3) retrospectively, because this has otherwise come into effect from 1/4/2022. Let's hear this matter again when.
After vacation.
Yes, I'm not here. So these are the 2 points. One is if there is no DAR, anything or no action is being taken by here, why not then the basic intention behind 166(3) gets negated. Or second is the question of bringing 29(1). Can it be done? But matter being heard at length, this court would fix this matter for further hearing on 29th of April 2025 for the matter. Hey. What is this?
But I have approved this court on being agreed by an order, my lord. Therefore, my right to file the written statement has been closed, my lord. My lord will find the order at page number 45.
So on the same day, he has kept it in abeyance, and on the other thing has filed the return, means debarring,
90th.
because you have completed 90 days.
On that particular day, it was the 90th day of that.
It was exactly the 90th day. Yes, what do you have to say?
This was on the 98th day, the petition under order 7/11 was filed.
What?
On 98th day, the petition under order 7/11 was filed. With a prayer for filing a petition under section 151 to keep in evidence the filing of written statements.
So how the court keeps it in abeyance and debars him on the same day? That is the
That
question.
was not kept in abeyance, but petition was rejected. Section 151.
No. You see, it is order.
Section 151 of the CPC, saying to keep evidence of the return filing return statement. That was.
No. Kindly see page 45. The last line. Considering the above, the instant suit is kept in abeyance till the disposal of petition number so and so. Okay, so on the very day, the court keeps it in abeyance, and on the very day he does this.
Considering the above, the instance should be kept in evidence in disposal of the.
How do you do that? Isn't it? Your written statement is ready.
He may file, otherwise it is ready, but as soon as my application is decided on the 7/11, I'll file it. The suit has been.
You file
No,
it,
no, no, sir, there is-
you have to file it within 10 days.
But I'll file it.
We will look into it later. So whether you file your written statement within 10 days. I fix a date. When is your Bihu vacation?
From 11th, Lord, sir.
11th. 11th is the last day.
Yes, Lord.
File your written statement on 11th. Let him file the written statement, immaterial of whether the suit is in abeyance or not. Let him file the written statement, keep it on record. Because what happens unnecessarily, this trouble is not there. Because if I allow him after the disposal of that, it will again cause another problem. You file your written statement, 90 days, you have got enough. And the basis reason, why have you filed this application on the 98th date? Order 7, Rule 11.
Got instructions accordingly, I filed it. I'll file it on 11th.
And why Order 7, Rule 11 has not been disposed of?
No, my lord, they are yet to file the objection. It is fixed on, my lord, 21/5/2025. It is fixed on 21/5, my lord. They have not filed the objection.
21/5.
So in the meantime, one of the plaintiff died, lord. The respondent before this honorable court.
Right?
Yes,
You have substituted,
we have already filed petition, lord, sir.
not substituted.
Not yet substituted, but file the petition for submission within prescribed period of limits. My lord, in that case, I will also have to file an application here, my lord. The respondent number 3 before this honorable court. Raymond.
So was he alive as on 29/7,
He died on 12/1/2025.
25?
12/1.
Respondent number
The 3 here, my lords.
3. Who are the substituted people? You filed an application for substitution.
Before the trial, yes, lords.
Give me copy. You will be appearing on behalf of these people?
So, sir, after filing the suit, there is some dispute among the plaintiff lords. There is some dispute among the.
I am asking, are you going to appear for these
I
people?
think I am not going to appear for you, sir, for the legalness of substituted plaintiff number 3.
And this order was passed prior to that.
This was on my lord 29/7/2024. 5 tablets.
Now, the thing is like this. I can substitute them here. Without an application also that can be done. No problem. But when did you file it? You filed it at the time when the person did not die.
Filed it in the month of October, my lord.
Huh?
I filed it in the month of October, my lord.
Because there cannot be a substitution there also because I have stayed here. There it cannot happen, so I have to first include them here.
Yes. At the time of filing the petition, he was alive.
Ah.
The petition was filed in the month of October, and he died on 12/1/2020.
But you can appear. You can appear, I can finish it off here, no, asking them. Because in view of the recent
Sir,
judgment of
yes,
the Supreme
sir,
Court,
there-
you don't
there
need
is
to
some
file an
dispute, sir.
application. Once it is come to the notice of the court, if it is within the time and when the petition was filed.
There is some dispute, let's say, after filing the substitution, for which the petition for substitution was filed by some of the plaintiffs also. All the living plaintiffs did not file the petition for substitution legal as of plaintiff number 3.
But are you not appearing in the trial court?
As on today, I am appearing also.
Then?
The-
So
as-
there will be a separate counsel for them. Yours too, we should proceed.
They ought to have give us formal instruction not to conduct a case on behalf of them also. They ought to have informed me also. Because the Ukalaknama was signed by them. Formal instruction should be given not to conduct the case on their behalf.
They have not given.
Yes, not yet.
And today they have given you to instruction to appear here.
No, sir, I am appearing on behalf of the today, Lordship. I am appearing on behalf of respondent numbers 1, 2, 6 and 7. 1, 2, 6 and 7.
What about the others?
I am representing Lordship, respondent number 9. Performer, Lordship. Performer.
1, 2,
1, 2, 6 and 7. Lordship.
others have not approached you.
Yes.
You are appearing for 9.
9.
But service upon everybody is complete.
But this honorable court has issued dusty, my lord, and I have gone and taken steps, my lord, but some of them have not received it. Only few of them who have
You have
received it.
filed the state.
Otherwise, the AD card and everything have gone, my lord.
PDA card has come back.
Yes, some of them have come back. That are-
No, not some of them.
Office with
Affidavit file has been marked as annexure here. You have filed an affidavit, no?
Yes, ma'am.
Of service.
Dusty, my lord, I have filed.
Huh?
Dusty only 8 and 9 have received, not others.
No, but have you mentioned that you went to them and they did
Yes,
not have
my lord, I
refused? Okay. No, if they have refused, we accept it.
Yes, my lord. In all
Okay.
the notices it is written, my lord.
Huh?
My lord will come at page number, my lord, 80. This notice was issued to my lord. Defendant number 6. The person who has gone, she has made her signature, the petitioner, my lord. Here, refused to accept.
But how do you say that a dead person has refused to accept?
6 is alive, my lord. It is only
Huh?
3 who has, 3 is dead, my lord. 6 is alive.
So how do you say in your affidavit, the respondent number 3 has refused to accept? He is dead. How did you say?
Lord, in fact, what has happened? This
It's a
particular,
false affidavit.
this particular person has gone there. She was threatened that if you come here, then we are not ready to accept it on behalf of
Now,
anyone.
why is that person going? I don't understand. Why don't you employ your clerks? They'll get some more money. No. This is the reason why I give it. That person is not
They
never
are
going to
not
go.
in a position to pay the expenses for this approval. To be very honest. For the petition also. They're very poor people, my lord.
So this is a false affidavit.
No, my lord.
Yes.
This is exactly what has happened, my lord. They have
Cannot be,
refused,
if
my
a
lord.
person who is dead on 12/1/2025 and you file an affidavit on 21st of March 2025 saying that that person has refuse to accept? How is it possible?
But they all reside together, my lord.
I don't understand, but how did you make that statement? It's a false affidavit. What is the now the recent provision of law to put you behind criminal proceedings? What is that? 391 or what nowadays? It's a false affidavit. On this ground only we should dismiss your petition. Giving a false affidavit, exercising the equitable jurisdiction. Chalo, dismiss on that ground. Go wherever you like. Pursuant to the service of notice, pursuant to the directions passed by this court, on 12/2/2025. The petitioner herein have taken steps by way of registered as well as usual upon the respondents. In pursuance thereto, Mr. R. Sharma has appeared before this court on behalf of the respondent numbers 1, 2, 6, and 7. And Mr. So appears on behalf of the respondent number 9. This court have also taken note of the affidavit of Dusty, affidavit of service, wherein it is seen that the petitioner number 2 have sworn on oath that the respondent numbers 1, 2, 3, 4, 5, 6, and 7 have refused to accept the notice. This court further takes note of the submission of Mr. R. Sharma appearing on behalf of the respondent number 1, 2, 6, and 7, who is also the counsel for the plaintiff in the trial court, and submits as to how the respondent number 3 can refuse when he had expired on 12/1/2025. In this regard, he therefore submits that as far back as on 25/3/2025, an application was filed before the learned trial court informing about the death of the plaintiff, the respondent number 3 herein on 12/1/2025 and seeking substitution. From the above, it is therefore clear that the statements made in the affidavit of service in respect to the service being refused by the respondent number 3 and 5, 3, 4, and 5 appears to be not correct. 3, 5, 3, 4, and 5 and 8 appears to be not correct. 8 you are appearing.
Fine.
On 3, 4, and 5 is not correct. Considering the above, the petitioner is directed to effect service, press steps upon the respondents number 3, 4, and 5. Press steps upon the respondent upon the unaffected upon the respondent number, upon the respondents who have respondents 4 and 5. Was taking into account that the respondent number 3 had expired, which have been brought to the attention of this court, and by Mr. R. Sharma. And he submits that the respondent number 3 herein is survived by his legal representatives, that is his wife and children, this court, in the spirit of in exercise of the power, in the spirit of Order 22, Rule 4, substitutes the respondent number 3 with Srimati Mitali Boro, bracket wife of late so and so. Here, respondent number 3, number 2, Sri Dibraj Boro, son of so and so. Srimati Mita Boro, daughter of so and so. The respondent number, the said sons and daughters, it has also been drawn, it has also been brought to the attention of this court that the respondent number, that Sri Dhiraj Boro and Srimati Mita Boro are minors. Accordingly, they would be represented by their mother. Taking into account the above, Srimati Mitali Boro, Sri Dibraj Boro, and Sri Mita Boro are substituted against the name of the respondent number 3 as respondent number 3A, 3B, and 3C. The counsel appearing on behalf of the petitioner is directed to take fresh steps upon the newly substituted respondents by way of registered as well as usual. In addition to that, the respondents, this court inquired with, fresh steps. So, this court, therefore, in addition to the direction for taking fresh steps upon the respondent numbers 4 and 5, further directs the petitioner to take fresh steps upon respondent numbers 3-1, 3-2, and 3-3 by way of registered as well as usual. It's the matter again on 2nd of June 2025. Interim order passed earlier shall continue. The counsel for the petitioner is directed to file a fresh memo of parties. Registry he has steps during the course of the day. Who take this?
I have submitted undertaking.
What undertaking? For that?
Yeah, in terms of
Where's that order?
It's reported now, 2025 1 GMT.
They reported. Good. So you get this order from some other court. I'm too busy. I don't have time today to sign.
Lordship papers letter on the. See,
No, I'm not there. I'm going away for 2 weeks. Then BU is coming. Another 2 weeks. Then I may be here.
hardly 5 minutes to take.
I hope.
There are 1567.
I was supposed not to pass long orders. Heard Mr. S. Sahu, the learned counsel, appearing on behalf of appellant petition, and Mr. Iber,
A.
A, learned counsel, appearing on behalf of the respondents. This is an application under, why 115?
51 because
115 is not maintainable.
earlier appeared on.
No, there were, I still remember, and I think just Chief Justice Goel was there. Yeah, Chief Justice Goel was there. Many petitions were dismissed as being filed under 115. It should have been filed under 227. And in view, more particularly in view of Surya Devi, Surya.
Once I filed 227 earlier in the year 2015 or 16. Lordship N. Choudhury. He asked me to file 115.
So, what to do?
Otherwise, I have invoked 227.
There's another judgment of the Supreme Court, High Court, you can't invoke both. Isn't it? Yes.
The wrong putting of results of law may be excluded.
Reason is the power is different. One is supervisory, one is revisional. Revisional goes on to the question of jurisdiction. Supervisory goes to the concept that when it shocks the conscience of the court, it does not shock. That is a FAO. Isn't that an FAO? Tell me.
Wrong putting may be excused. But
How can there be a wrong putting? Let us have 115 not possible. Because you are in the second stage. Eh? Injunction first, second, we are in the third stage. So when in the third stage, you are almost dead. You want to die more. What is shockingly disproportionate? Tell me. This is an application filed under Article 227 of the Constitution, invoking the supervisory jurisdiction of the court. Challenging the order dated 16/11/2024, passed in Miss Appeal number 1/2023 by the learned additional judge Biswanath at Biswanath Sariali, thereby granting prohibitory injunction by reversing and setting aside the order so passed by the learned trial court in Mizze case number 3/2023, whereby the injunction application was rejected. For the purpose of deciding the legality or otherwise of the impugned order challenged, this court finds it relevant to briefly take note of the facts which led to the filing of the instant petition. The respondent herein, who has filed?
Respondent filed.
Okay. The respondent herein as plaintiff had filed a suit being titled suit number 6/2023 against the petitioner herein, against the petitioners herein. The said suit was registered and numbered as title suit number 6/2023 before the court of the learned civil judge at Biswanath Sarili. The brief facts of the case. You file counterclaim also.
Yes, ma'am.
Of the respondent. That the respondent, that the plaintiff of the plaintiff, that he had that the plaintiff had to undergo treatment at Ayusandra Super Speciality Hospital in Guwahati on and from 23/6/2022 up to 6/9/2022 for sudden onset of LOC and vomiting, altered sensorium, one episode of hypoglycemia, etc. Prior to the enrollment to the said hospital, the plaintiff had entered into an agreement with the defendant number 1 by deed number 524 dated 16/10/2020 for sale of a plot of land measuring 1 Katha 5 lechas covered by dag number 97 of Epipatra number 150, situated at village Bamgaon under Moza Biswanath in the district of Biswanath. The land which have been specifically described in Schedule A to the plain. In terms with the said agreement, the total consideration value was rupees 42 lakhs. And as per the case of the plaintiff, an amount of rupees 8 lakhs was paid. It is a further case of the plaintiff that taking advantage of the plaintiff's unconscious condition, the defendant got executed one agreement for sale bearing deed number 137 for the year 2022. On 8/9/2022, in respect to a plot of land measuring 9 lesas covered by DAG number 99 of Kiras Pier, Miadi Patta number 150, and one sale deed bearing deed number 874 for the year 2022, registered on 8/9/2022 for consideration value of rupees 7,20,000. Only in respect of the plot of land at measuring 16 lechas covered by DAG number 97 of Khiraj Miadi Patta number 150, both situated at Sariali Nagar Fourth Part, Bamgaon, under Moza Biswanath in the district of Biswanath. The 9 lesas of land in respect of which the agreement for sale was made, have been specifically described in Schedule B to the plain. The 16 lesas of land which have in respect of which the deed of sale was executed was specifically mentioned, described in Schedule C to the plain. The further case of the plaintiff that the plaintiff was only paid an amount of rupees 8 lakhs and without making payment of the remaining consideration as was agreed to in the agreement dated 16/10/2020, the defendants have fraudulently executed the agreement for sale as dated 8/9/2022, as well as of the deed of sale also dated 8/9/2022 without 8/9 in respect to the Schedule B and C land respectively. It is under such circumstances the plaintiff filed the suit for declaration of right title and interest over the land described in Schedule B and C with consequential relief of recovery of possession, thereby demolishing or uprooting the foundation of the post of proposed RCC building and the CIC Chatai wall shared with men and materials therefrom, semicolon, for declaration that the deeds of agreement for sale and the sale deed as described in Schedule D are null and void, inoperative in law, and liable to be cancelled, and for permanent injunction. Along with the said suit, an injunction application was filed seeking an ad interim temporary injunction on the facts which are similar to the facts mentioned in the plaint, and seeking an ad interim temporary injunction restraining and prohibiting the plaintiff, the defendants, their men, agents, workmen from digging and constructing any houses, structures in the suit land or any part thereof as described in Schedule A, B, and C to the plain till the disposal of the suit. Any ex parte injunction?
No.
It is seen from further from the records that the defendant thereupon filed their written statement wherein various preliminary issues were taken as regards the maintainability of the suit. It was also mentioned that the entire amount of consideration was duly paid.
Sir.
Or you did not pay?
Some is left over.
How much? 15 lakhs, 50,000. Now you want to construct, you are constructing in which land?
Because that's schedule A. Schedule A. The schedule A and B is the part.
B and C.
B and C is the part and parcel of A.
Now your sale deed is only in respect to one portion.
Yes,
How are you going to construct in the other?
because he has admitted in the plate itself. Earlier, they have thought that this entire land belongs under 199. Later on, they came to know the out.
I'm not on that.
Below.
But admittedly, only 16 letters have been sold to you.
Yes,
How can you construct in the remaining 9? How can I give you the permission to construct in the remaining 9?
position.
The 53A.
Below.
The moment I give you this will have far-reaching consequences. Not possible this type of order. You can construct in 16 is okay. 16 letters, but how do you construct in 9? There's no agreement sale deed in respect to 9.
Agreement.
Only agreement for sale is there, no sale deed.
There is a sale deed for 16.
Only 16 letters, 9 letters, no sale.
So 9, you cannot construct there.
That is why this undertaking is also given.
You undertaking given, but the moment I permit you to construct means I'm creating a right upon you. I'm not here to create rights. I'm here to adjudicate.
Almost
Impossible.
building is there, Milord.
No.
Erected, Milord.
Tomorrow it may be demolished, it's a different thing. But the fact remains out there. But how do I give it? In respect to that 9 letters. You can't construct on 9 letters.
He has admitted that he has agreed to sell that land. He has admitted because in the year, the agreement made in the year 2020, he has admitted. That was a part of that agreement. So when he has admitted, Milord, then Milord, that my decree for special performance is there, Milord, because on admission I can claim that, Milord. He has not said that I have not agreed to sell that land.
No, she agreed in the initial, the first one.
Yes,
But is that a registered document? The
yes,
first
oh
one?
yes, both. All are registered. Registered. All are registered. But my counterclaims can be decreed on admission,
Subject to deposit.
That is there, Only that consideration.
The defendants herein, the petitioners herein who are the defendants, file a written statement along with the counterclaim. In the written statement from counterclaim, it is being stated. The case of the petitioners is, defendants are that the initial agreement that the agreement dated 16/10/2020 was a registered agreement for sale of 1 katha 5 acres of land covered by Dag number 97 of Patta number 150. At the time of when the sale permission was sought for, it was found that a portion of the said land which was agreed to fell in Dag number 99, that is 9 acres, and the remaining portion of 16 acres was in Dag number 97. Accordingly, the deed of sale was duly executed in respect to the land of 16 acres, that is Schedule C land. Schedule C land by a registered deed of sale dated 8/9/2022, and a fresh agreement for sale was registered agreement for sale was entered into on 8/9/2022 in respect to the 9 acres of land covered by Dag number 99 of 99, which is the Schedule B land. It is under such circumstances, it was stated, that in respect to the Schedule C land, the entire consideration was duly paid, which was duly acknowledged even in the deed of sale. Also, in respect to the Schedule B land, the plaintiff, the defendants have requested the plaintiff to execute the deed of sale, which having not been done, the counterclaim has been filed seeking specific performance in respect to the Schedule B land. On the basis of the sale, in similar terms, the written objection was also filed. The learned trial court, by an order dated 9/11/2023, in Miss J case number 3/2023, rejected the injunction application, holding inter alia that the balance of convenience as well as the irreparable loss holding inter alia, that the factors pertaining to balance of convenience as well as the irreparable loss, harm, and injury were not in favor of the plaintiff for grant of an injunction. It was a specific observation made in the learned trial court has specifically opined that the defendants, pursuant to the deed for sale, have already collected huge building materials, and if they are restrained by way of granting temporary injunction from carrying out further construction without deciding the validity of the registered deed of sale, it will prima facie restrain the opposite party from enjoying the prima facie right over the suit land acquired through the registered deed of sale, and all the building materials will get damaged, due to which the opposite party would face inconvenience. The defendant would face inconvenience and would also suffer huge loss. The learned trial court further also opined that in the circumstance the suit is decreed in favor of the plaintiff, there is already that the plaintiff would automatically get possession of the suit land by demolishing the houses and materials. In such situation, the balance of convenience was in favor of the defendants for not grant of an injunction. Next, the respondent herein, the respondent herein being aggrieved, the plaintiff herein, the plaintiff being aggrieved, preferred an appeal before the learned first appellate court, that is the court of the learned additional district judge Vishwanath Saryali, which was registered and numbered as Miss Appeal number 1/2023. The learned first appellate court interfered with the order passed by the learned trial court rejecting the injunction application and was of the opinion that the plaintiff had a prima facie case. The balance of convenience was in favor of the plaintiff for grant of an injunction, and further that the plaintiff would suffer irreparable loss, harm, and injury. Under such circumstances, the learned trial court directed both the parties to maintain status quo till the disposal of the suit, and the defendants were directed to abstain from making any construction on possession over the suit land. It is under such circumstances the present proceedings have been filed. Mr. Esau submits that the building in question is almost complete. And the learned trial court and complete. And there are certain building materials lying. And if the plaintiff building is almost complete, and by virtue of the registered deed of sale, the plaintiff, the defendants have the right to carry on the construction and enjoy the property. He further submitted that the only issue with the plaintiff is non-payment of certain amount, which, and as such, the question of there being an irreparable loss, harm, and injury cannot arise. He further submitted that the plaintiff, the petitioner, have already, the petitioner, the defendant, with the petitioner herein, is not adverse to giving an undertaking to the effect that the defendant shall demolish any construction made during the pendency of the suit and hand over the possession to the plaintiff. In the circumstance, the plaintiff succeeds in the proceedings initiated by him. The learned counsel further submits that the plaintiff and the defendants are also agreeable to give an undertaking that the defendants shall not create any third party right over the suit land during the pendency of the suit. Why there are two defendants?
Husband and wife. All the agreement was in the name of her wife.
Who is the husband is petitioner number two.
Yes. Petitioner number two. Petitioner number two, defendant number.
He further submitted that in that regard, an affidavit has also been filed by the petitioner number two.
What?
Petitioner number two. Who is the defendant number? Two in the suit. And in whose favor the sale deed as well as the
Petitioner number one.
Huh?
Not two. Petitioner number.
why it is being given by defendant number two, the undertaking? Why you are not giving petitioners? There are two petitioners. Why you are giving only one undertaking? Unnecessary spoiling my time.
No, defendant number two has nothing to do with it.
You are this
The
undertaking is
petitioner
being
number
given.
one is giving undertaking on behalf of petitioner number two as well as.
Mr. Counsel,
Yeah.
why you are not understanding? What is the undertaking given?
Undertaking is given by the, because all the agreement is in the name of petitioner number one, we got.
Sale deed?
Hello?
Sale deed is in name of whom?
Petitioner number one,
Petition number one is the defend number one.
yes, my lord.
Then why the undertaking is of defend number two given?
No, my lord, both of them given.
Where?
Yes, my lord.
Where?
I undertake and I sell on my behalf and on behalf of defendant number two, demolish any construction, my lord.
How can one given the undertaking? We it has to be. Cannot be I. That means only one will give, the other one won't give.
Because, my lord, defendant number two is only formal party, my lord. All the agreement, sell deed is in the name of petitioner number one.
But by the petition has been filed by both the defendants. That is the problem.
And he has authorized to, you know, he has authorized the petitioner number one, two.
Where?
Yes, my lord. That in the undertaking itself, my lord.
Where? Sorry. Unhill. Please come back. Unhill. Please unhill. You are spoiling my unnecessary time. The entire time you.
I shall file first, my lord,
When?
by Monday
I'm not here.
on 22nd, my lord.
Hey,
On
come
22nd.
back, hey, it will have. An affidavit has been filed on behalf of the petitioner number one. The said affidavit. But however, it is relevant to take note of. An affidavit has been filed by the petitioner number one, giving an undertaking on behalf of the petitioner number one as well as the petitioner number two. In the opinion of this court, the undertakings, the said affidavit cannot be said to be an undertaking given by the petitioner number two. Under such circumstances, on the basis of this undertaking, this court cannot pass an order as sought for by the learned counsel appearing on behalf of the petitioner. This is the matter again on 22nd of April. He is calling my time.
By the time I will be allowed.
What is wrong? Mr. You ask him, Mr. Samnur Ali had 4 dates, na? 4 affidavits he has filed. 4 times. I made it very clear. I trusted. Here it was categorically given. Then also. And here why you have done, do you know the mistake you have committed? You saw this. But there he gave because the defense number 2 out there was a company. My goodness.
but that line was left out.
Okay, 10,000 cost I think should be given. You've spoiled so many. And all the other councils should be shared with this 10,000.
The
No.
cases so far that may be kept, I find.
I won't be picking up. I'm a criminal bench.
Appeal against the rejection of a claim.
Appeal against the
Rejection of a claim, of the claim itself.
why?
The grounds of rejection is no eyewitness was there, Lordship. Though there was a FIR registered, there was no FIR on behalf of the claimant. On these are the two grounds for which is primarily rejected. Page 56 it starts, page 64 are the grounds 63 and 64.
Who died?
My husband. My husband was driving the tractor and the offending vehicle Wagoner collided.
The tractor was yours.
Yes. Then he was taken to hospital. Police came to the spot also, registered an FIR also, Lordship, under 279. Yes, case number 116 of 2021. 3048.
You are not an eyewitness.
No eyewitness.
Then,
Then, no, Lordship,
whereas the FIR says that your husband was the person who has caused the rash and negligent driving.
Lordship, I was in a tractor, Lordship.
Tractor having an accident with a Wagoner.
Wagoner, Lordship, the
And
tractor cannot move
and
at
the
high speed.
tractor person dies. Obviously, the responsibility is, are you going to tomorrow say that an elephant and a small what you call an ant dies out of there, and the elephant died because of something, and you are going to say that the elephant was the person?
The
Something
tractor
like that.
was
Tractor
carrying
is such a
leaf,
big
so
thing.
cannot move at a high speed, Lordship.
Then
And moreover, Lordship,
what proof did you give? No proof.
Lordship, in the claim petition, in the evidence in affidavit, and in the cross examination, I deposed that it was in the high speed and the Wagoner, the accident took place due to the rash and negligent driving of the Wagoner.
How? How did you depose? You were not there. Claimant was never there.
Yes.
Then,
No, I, Lordship.
so if there is no eyewitness, then how did you prove that this has happened? If issue number 1 is decided against you, other issues fail.
Lordship, the standard of proof taken by the learned member was what is here in the criminal trial, Lordship. However, Lordship, the probable.
Probable also, you have to give something. What is the probable? A person who has not heard, seen, done anything. That's the evidence.
Lordship, there is a postmortem, the FIR is also filed, which is under investigation. Therefore,
The FIR says otherwise. You did not file an FIR. FIR has been filed by the other side, saying that your husband was responsible for everything.
the only thing that I did not file the hazard.
No. There was no other witness. If the charge sheet would have come up and said that no, there was some evidence, then how will the court decide? Tell me.
The charge sheet is yet to be filed. Lordship. It is not been filed yet. Moreover, Lordship,
Accident happened in 2021 and till now no charge sheet filed.
Lordship, this morning I inquired, Lordship, they say that it is still under, the child court lawyer says that it is still under.
It's the matter after 4 weeks. In the meantime, if you get the charge sheet, file an additional affidavit. And if not an additional affidavit, an affidavit under order 41, an application under 4127 for bringing additional evidence. The charge sheet says something.
For orders item 9.
The amount has been sanctioned. So far as the caretakers, that is also sanctioned.
Huh?
31st money is the deposit. Or it is already been deposited with council. The amount has been released. Will go to our account.
So we close this.
He is not present today.
It's okay, we can close this. Again, they will come. Liberty is still there.
You might understand. Absolutely.
And instead of sending the report, Mr. Gogoi, to me every time, ask the superintendent to give it to her.
Right.
Not me. What am I going to do? It is seen that that the order that is seen that pursuant to the order dated 17/3/2025. The
The same.
the finance department have already released the ceiling of rupees 83,602, isn't it?
Yes. Okay.
Both are same.
Same. One is fine.
And the petitioner herein have been receiving the dues in terms with the judgment and order dated by final order.
That was the final order.
My final order. Judgment and order dated 22/12/2023. And considering the above, this court therefore closes the instant proceedings, as nothing further is required to be done. Be that as it may, this court, be that as it may, this court keeps the liberty as granted in the judgment and order dated 22/12/2023 at paragraph number 30 Roman 9 open, and the petitioner would be entitled to approach the Secretary District Legal Services Authority Dorong if the directions contained in the judgment and order dated 22/12/2023 is not complied with in future. The sealing, the fixation of sealing is kept on record and marked with some letter over sign. There. What is the case made out here? You are appearing for
Respondent.
claimants.
Respondent.
You're the claimants. You got the money?
50%.
What is this? What are you challenging?
Lordship, in this case, we are selling the quantum of the award, Your Lordship.
Then why do you need 10?
We are praying for taking down this name. Your Lordship.
Taking into account the scope of the instant appeal, whereby the insurance company, appellant insurance company have only challenged the quantum of the award. And not the settling of the liability upon the appellant insurance company, comma. The respondent, the name of the respondent number 10, the respondent number 10 to the instant proceedings is struck off. List the matter for hearing. What is the quantum?
Lordship, 8 lakhs.
Why are you challenging the quantum?
Your Lordship, the multiplier and the income was not properly adjudicated, Your Lordship.
Why? You ready, madam? You ready?
I have
Hearing?
difficulty today, Your Lordship. I'm having some difficulty. Next week, Your Lordship, can you get?
Taking into account that the instant appeal is almost pending for almost a decade. The matter for hearing on 6th of May 2025. Liberty given to both the parties to mention the matter for hearing.
Your Lordship. 11.
Yes, service complete.
Lordship.
LCR received.
Lordship.
Service being complete and LCR being received, list the matter for hearing on 13th of May 2025. Liberty given to both the parties mention the matter for approval, taking into account that the appeal is of the year 2006.
I love this.
Well. Yes, everybody appearing?
That's
Your
it,
Lordship.
saying,
All the respondents have entered appearance, Your Lordship. NCR has been.
Account that the respondents are duly requested and the appeal here having been received, list the matter for hearing. To be given to the parties to file application for hearing.
Okay.
13. Look this.
Is to take instructions regarding the consideration of the cases by the respondent.
Yes, I've asked you to file some petition. Better in both the parties, no? Where's the other side? There's the top. Help it.
In this regard, we have to take some instructions in lawyers. And the company lawyers are in Bareilly, so we, main lawyers in the company registered in Bareilly, so we have taken some more instructions for lawyers in Bareilly. Consult some other.
Because there has to be in one place. You are for whom? For the company. It will be easier for you here. You have filed the suit here.
Yeah, we have filed.
The suit is the first one.
First.
Earlier.
There is a second one, after 1 month, they have filed it.
No. Your suit has been stayed. No, it has not been stayed. Taking into account that the counsel for the respondent is not represented, and this court had inquired by the order dated 17/3/2025 for obtaining instructions. This matter again on 11th of April 2025. 14 for admission.
There is an order for taking fresh steps in respect to respondent number 12, collecting new address. Her new address, we could not find lawsuit, but she is a pro forma respondent, we do not have any claim against her. We may have stuck on it.
If the procrastinator, the counsel submits that the name of the respondent number 412 can be struck off, taking into account that he or she was a performer. Accordingly, the name on the is struck off from the post list. He is the counsel appearing on behalf of the appellant is directed to file a fresh memo within 7 days, and history shall take in legally. Further to that, taking into account that the service is complete and the LCR has been received, is the appeal for hearing in the usual course.
Apply.
15. What is the matter about?
Defendant lawsuit and the plaintiff. I have filed a suit for the senior petition number 1 Kamruk Petrol lawsuit for
Wait. Why have you filed this case?
It's a fairly.
I filed today. What is it challenging?
They have filed on a rejection of plain filer that was rejected by the Lanet Secretary on over Kamruk Petrol. They filed on this ground.
Mr. Kyle, your matter. Is your ground for rejection of the claim?
Ground only the non-tender of necessary parties.
What happened, the petitioner, respondent filed a suit against her 2 sisters. And there are 4 sisters were there. She was not implicated.
Huh?
They were 4 sisters. The suit was filed against 3 by the respondent against 3 sisters only. She left out 1 sister.
And
That's why we file application for registration of the claim on this
how
ground.
is it maintainable?
But see,
It may be tomorrow, it may say that, okay, the suit may be bad for that. Non-joinder of necessary parties. But
But
can
it-
it be said to be barred?
no, but see, here, this, our ground was that in plaint they have stated lawsuit. In the body of the plaint, there are 4 sisters. But, practically they didn't make, another legal issue of other sisters.
So for that, the suit will be bad.
But that
But
is-
how can you reject the claim? Can you say that it does not disclose a cause of action? Can you say that it is barred? No. Where is it mentioned that it is barred? No case.
But see, what happened, we appeared
You are
for,
a defendant.
I'm defending.
You've got a stay.
But if no, stay was, here we go.
We get the stay and fight it out. And admit this for all times to come. Unnecessary. Which one do you want? Vacate the stay or dismiss your petition? Or you withdraw the petition? 3 of the conditions given. Which one? Vacating the stay with cost from 2023, 2 years. Isn't it? And he can very well file an order 1 rule 10 and get it done. How does it happen? How do you file it on this ground? Lahok. Dismiss with cost of 15,000. Heard Mr.
Regarding post.
Unnecessary stay.
No, that's it, we made out some case and the.
No case.
Section 6 of the transfer property, they have to make all the legal as a party. But the
Ah. Under section
6 of the transfer of property, Act,
six.
all the legal, all the sisters are required to be made party.
Show me where. Section 6 of the Transfer of Property Act says such. Never heard that. Other section 6C.
But it page 10 ground B. All the living heirs are necessary party.
Where?
We have made in paragraph,
Down?
all the, that for all that under the transfer of property, all living heirs are necessary party. And property is to be divided among themselves in equal shares. In the instant case, the plaintiff did not complete legal heirs of late Lina Chaudhary and prayed for a decree for partition and property and claiming 1/3 share there.
Where? Show me where is the bar? Under section 6.
The bar is not there, but
Then on the what basis?
all the legal side should
Who
be.
may be transferred? That is why I was thinking section 6 is who may be transferred. I thought what has happened, I forgot. Section 6.
My submission is that all the living heirs, legal heirs are necessary party in a partition suit. This is my,
Dismiss with cost.
then of I may be allowed to withdraw. I will contest in the.
The Kyle, the learned counsel appearing on behalf of the petitioner submits that taking into account that application that taking into account that non-impleading legal representative not come within the ambit of order set in A or D of the Code of Civil Procedure for rejection of the claim. He would not like to press the instant petition. Accordingly, the instant petition stands closed. Withdrawal have also taken that on 7/6/2023. The further proceedings of petition number 65/2022 pending before the court of the judge number 1 Kamrup Metro. With the senior division. Senior division number 1 Kamrup Metro at Guwahati was stayed is hereby vacated and as the parties are duly represented before this court, they are directed to appear before the 7th of May 2025.
In the meantime, Lordship, there is no presenting of this report.
There is no presiding officer in the court.
7.5.
You'll get it. Don't worry.
Ablaji. 16. My lord, here in this case, my lord, service is complete, otherwise family dispute. One round of discussion already held. Second round discussion are going to held, my lord, shortly, my lord. So I pray that sometime during the current year. Otherwise, my lord, one development is that the titles to this in connection with this instant CRP, my lord, that has been rejected by virtue of Order 7 Rule 11.
What are you challenging?
My lord.
What are you challenging?
That's why, my lord, Lord, I just want to bring on record that.
No,
point.
no,
Just
let
one
us
date, my
come
lord.
back to the point. What are you challenging? Miss appeal?
My lord, yes, miss appeal, my lord.
For what?
My lord, my injunction prayer, which was, my lord, I have opposed against them, that was rejected, turned out.
You
That-
had paid for an injunction.
Their paper status to order was granted, that affects me. I filed appeal, that was rejected against this.
Now what have you got here?
My lord, the thing is that, my lord, discussion is going on to sort out the problem between the parties, my lord.
And why is this judgment stayed there?
My lord, the reason is that, my lord, prior to
So
dismissal,
there is no status quo.
as of today, no more.
You vacate it.
Why not, already the Miss case is disposed by the court below, my lord. Miss case is disposed and status quo order is up it. So this appeal is not,
No doubt.
appeal is not, madam, because already Miss case is disposed of by the court.
No, no, the trial court granted you a status quo.
Yes, my lord,
Appeal filed, appeal dismissed.
yes.
But-
Hereafter, my lord, court below already disposed the matter,
Is it?
awaiting the order. Status quo.
You challenged an interlocutory order,
Yes,
i-
madam.
ad interim order.
Yes,
Status quo.
Afterward, my lord, that suit was dismissed by virtue of Order 7 Rule 11 effect.
Order 7 Rule 11 suit has been rejected.
Already I have filed the appeal, my lord, appeal is pending in this regard.
So nothing remains.
As on today, nothing.
Nothing.
It has been submitted that nothing remains in the instant proceedings, taking into account that the suit which was filed was the suit which was filed being title suit number 9 of the 2022 have already been disposed of upon rejection of the plaint in the said suit. Taking into account the above, nothing further remains in the instant proceedings for which the proceedings stands.
17.
Interim orders of any standard.
This matter has become infructuous.
Mr. S.R. Bulwer, the learned counsel, have, Mr. S.R. Bulwer, the learned counsel, appearing on behalf of the petitioner, submits that the instant proceedings have become infructuous. Why?
Lordship, both the parties have already obtained their degree of divorce on mutual consent.
In the meantime, both the parties have already
Obtained the degree of divorce on mutual consent.
obtained a decree of divorce upon mutual consent. Considering the above, nothing, the instant proceedings stands closed on as it has become infructuous, interim orders, if any.
Obliged.
18.
Yes, madam. Give your name.
Respondent number 1 has entered appearance. As per office note dated 28/24, respondent number 2A has expired, so name may be struck off.
Who expired?
2A. And service on the other respondents 2B, C, and D are complete as per the office note. Dated
Way may be expired
26.
because Aiki,
I was to stay. It was for stay, it was filed at the time of.
nothing.
Till the returnable date.
Now what do you want?
LCR may be called for and.
Way expired.
one has expired, name has been struck off. Plaintiff, petitioner number, appellant number one has been struck off already.
Then
Where may be struck off?
two,
2A,
respondent,
respondent number. two.
why?
Because 2B, C and D are in records, the legal heirs.
The BJ Mukherjee submits that the name of respondent number 2A may be struck off. Performer respondent number 2A may be struck off. Taking into account as the said respondent had expired and the estate of the performer respondent number 2A is represented by the respondent, performer respondents number 2B, 2C and 2D. Further to that, records, no records.
The same record was not called for while let me get the appeal list. 7/6/24 and date of admission.
Inadvertently, they have-
So it is, it is further seen that by an order dated 7/6/2024, the coordinate bench of this court had admitted the instant appeal by formulating a substantial question of law. However, the lower court record LCR was not called for. It has been submitted by both the parties that the LCR would be required. Considering the above, the registry is directed to requisition the LCR. Upon receipt of the LCR, list the matter for hearing before the individual courts. Liberty given to the parties to file appropriate application after receipt of the LCR before this court for early hearing.
Regarding IL lordship that is pending, regarding execution case, today they fixed the court below for necessary order because there is an interim order till returnable date. It was not continued also. That was IA.
You go ahead, he is not insisting.
Lordship, it may be extended.
Please do not
The interim may be extended, your lordship.
He didn't say anything. Why you are reminding him?
sign last sentence.
Stop.
The interim order passed
This
to the
court
court
having
order to
heard Mr.
reconsider
Vijay
after
Mukherjee, the learned counsel appearing on behalf of the petitioner. The learned counsel appearing on behalf. Seeing that this court have already admitted the appeal and called for the admitted the appeal by formulating a substantial question of law by an order dated 7/6/2024. Taking into account that this court is present deciding as regards the legality and validity of the impugned judgment and decree, is the opinion of this court states the impugned judgment and decree dated 14/8/2023, passed entitled appeal number 2/2023 by the Court of the Learned Civil Judge Senior Division Sirang, as well as any execution proceedings, well as execution, the title execution proceedings being title execution case number 4/2020 in the disposal of the appeal. I still disposal.
Apply.
Appeal.
In order to 5/7.
I only say, I know. I know.
CRP.
What is this?
Lordship at page 12.
Written statement not filed.
Yes, sir.
How much delay?
Lordship, the issue is that the plaintiff, the petitioner,
What?
the petitioner is trying to settle the by paying the loan. In fact, he is not denying that he has not been granted the loan. In fact, one of the petitioner has already paid loan in CRPR number 347 that they have issued a certificate, the State Bank of India,
Huh?
He will also pay. Sometime if the state bank grants.
No, no, no. Why should we stay anything?
Lordship, at page 12, your lordship will find the impugn order. Because the impugn order nowhere says that whether it should be proceeded expert in absence of the written statement.
Who has filed the suit?
Lordship, the State Bank of India, Lordship,
Against?
against me, Lordship, against the petitioner for recovery of loan.
Then?
And then the petitioner entered appearance to an engaged advocate.
Is a stay?
State Bank of India, Lordship.
Is a stay?
Lordship,
What is wrong with the order?
Lordship, the order nowhere says that whether it should be expertise against, in respect of the defendant in absence of a written statement, or it should be expertise against the defendant. That is the issue. If your lordship is the interim order, that reflects that issue, lordship.
Which order?
Interim order dated 6/11/2023.
Why?
There, lordship, this court has stated only on the issue that a question would arise as to whether in the absence of
I'm not
written
concerned with those type of orders. I'm only concerned with the impugned order.
lordship,
What is wrong with the impugned order?
lordship, some time could have been granted.
Why?
However, lordship, in terms of
Why didn't you file an application before that court?
an application was filed, seeking some time for filing wakalatnama.
Where?
That if your lordship peruses,
Okay,
defendant is
then
absent.
the next day, why haven't you moved?
Defendant is absent and by petition number so and so again sought for adjournment on behalf of the defendant. So some
Then?
time was taken. That has not been granted, and instead of granting that time, learned court will directly proceeded
When
expert.
did you receive the summons?
In the month of January.
Have you filed your affidavit of custody?
We have
There is
filed
a direction for taking
Yes,
steps by
we filed-
custody.
we have filed, lordship.
Have you filed it?
Yes, lordship.
Where? When did you do it?
On 9/11/2023. On 9/11/2023, we have filed the additional affidavit of custody.
No additional affidavit here.
Lordship, the website is showing, lordship. The website is showing that on 9/11, custody service has already been taken.
You have a copy of it. I'm not extending that order.
Lordship,
I'm dismissing your petition. Hello. When did you receive the summons?
lordship, that date is not known to me, lordship.
What?
That
Why
date-
did you file the petition like this without knowing anything? So, Leho, this is an application filed under Article 227 227 the Constitution, challenging an order dated 5/7/2023, whereby the learned court of the civil judge West Karbi Anglong, Amren, had in title suit number. What is the suit number?
Money suit
In money suit number 1/2023, have rejected the petition and direct and have rejected the petition seeking time for filing wakalatnama and written statement by the defendant, and further directed the suit to proceed ex parte against the defendant. The learned trial court by the impugn order further fixed 1/8/2023 for filing of written evidence on affidavit of the PW's public hearing. So the petitioner being aggrieved have approached this court by filing the present petition, and this court by an order dated 6/11/2023 had stayed the further proceedings of money suit number 1/2023 till the next date. The said order has been continued since then. It is also seen that the respondents have not appeared in spite of service being affected, as would be apparent from the office note dated 16/12/2023. Taking into account the materials on record, wherein materials on record, taking into account that the instant petition does not disclose as to when the summons were received, and except the fact that on 16/12/2022, the summons were issued to the defendant of the petitioner herein. And the next order which was passed, and the impugn order was passed on 5/7/2023. This court is of the opinion that the ends of justice will be met if the petitioner hearing is given another chance for filing the written statement. However, in doing so, this court cannot also be unmindful of the fact that there has been certain negligence on the part of the petitioner. Accordingly, this court interferes with the order dated 5/7/2023 and permits the petitioner to file the written statement before the trial court in money suit number 1/2023, subject to imposition of a cost of ₹25,000. This court fixes this matter, this court vacates the interim order passed on 6/11/2023 and directs the petitioner to file the written and directs the petitioner hearing to appear before the learned trial court on 21st of April 2025, on which date the petitioner shall is given a further liberty to file the written statement and deposit the cost of rupees 25,000. This court further observes and directs that if the written statement is not filed by the petitioner on 21st of April 2025 as directed above, as per the liberty given above, the learned trial court shall proceed with the suit in accordance with law. It is also observed that the deposit of rupees 25,000 as directed shall be a condition precedent for acceptance of the written statement. Above the petitions. Okay, 35,000.
Lordship, the Partition number is not correctly typed in the order sheet itself.
Interim orders, all interim orders.
Partition number 1 of 2022 actually.
What?
Partition number of 1 of 2023, it is written in the order, but it is 1 of 2022. And one I was filed, I number 718 of 2024, for correction of that particular thing, and that was subsequently corrected by the other people.
What is the number of the suit?
1 of 2020. But in the order itself, it is wrongly written. That
But how do you know? It is
Okay.
1 of 2022.
the copy of the summon I have. This is the copy of the summon I have. Copy of the summon I have. It is written as 1 of 2020. That the learned trial court has committed that particular error. And that is why this interim order was passed.
1 of 2022 going, huh? Two. 1 of
Twenty.
service complete.
Lordship, I am for the respondent, Lordship. The IA copy I have not received, Lordship.
I'm not on there, but I'm asking you, is the service complete? Are you appearing for all the respondents? Fantastic. Service complete. LCR received, leaves the matter for hearing in the usual course. Liberty given to both the parties to file application.
21.
Yes, Mr. Sharma, for APDCL to our second appeal, what is there?
Lordship, the service
Ah,
has been completed.
File there, file there. It's very important when Mr. Sharma appears. One should have the file.
Service has been completed upon all the respondents.
What?
Else, but however,
You're
the
appearing for everybody?
No, my lord, I am everyone except for respondent 15A.
Respond number?
15A.
Who are those?
they are the legal hires.
Performer?
My lord, also respondent number 8 and respondent 16 have died.
Huh?
Respondent number 8 and respondent 16 have died.
Service have been received from possessor in respect to here as follows. So and so. Respondent number 8, performer respondent number 16 expired. Possessor, performer respondent 15A, 15 duly served. So service upon these two persons have died, na? 8 and 16.
My lord, at the time of the filing, it was, at the time of the filing, we'll replace them, my lord. We'll substitute them, my lord, by their legal hires.
You don't need to bring the performer respondent 16. You can strike off. But 8 you have to do it.
My lord.
So your submission not necessary to substitute 16, but 8. Mr. S.P. Sharma, the learned counsel submits that taking into account the office note dated 7/3/2025, he would like to take steps as regards substitution of the respondent number 8. Yeah, he further submits that though the performer respondent number 16 has been shown to have expired, there would not be necessity of substituting him, taking into account that the appellant herein have not sought any relief against the performer respondent number 16. First, in that view of the matter, the name of the performer respondent number 16 be struck off. First of all, the appellant is given to list the matter after 6 weeks.
Much of that.
Twenty-two.
As per office note dated 19/24, respondent number 1 and 6 has filed wakalatnama.
Who is 2, 3,
See, my lord,
5, 7?
two, 3 are the claimants, my lord.
So without them, it can't be done.
Can't be done, my lord.
Taking into account that the service is not complete as regards the respondent number 2 and 2, 3, 5, and 7. The counsel for the petitioner appellant, Mr. A.K. Gupta, submits that he will take fresh steps. First, the steps be taken within 7 days. We shall list the matter after completion of service.
23.
And this second appellant, full respondent has appeared, and the LCR has also been received.
Mr. Gupta, you are appearing for whom? Owner. There's a stay.
Here, I'm for the respondent. 1, 2, 3.
1 and 6. 1, 2, 3, you are appearing. Which matter? 22.
Yes, ma'am.
22, na? You are appearing for 1, 2, and 3. Who is 5 and 7? Just 1 minute, Mr. Day.
Actually, I'm not a receiving it. On a,
It's okay, I understood.
there
So 1, 2, and 3 is done. 6 is done. Who is 5 and 7? So,
there are 2 vehicles involved, my lord.
Huh?
There are 2 vehicles involved, my lord. So the 5 and 7 are, 5 is the driver of another vehicle and 7 is the, my lord. That is also a driver of the, both are the drivers, 5 and 7.
5 is?
5 is, my lord, Abdul Jalil, my lord, he is the driver of a traveler.
And 7.
7 is, my lord, Muhammad Sariful Hassan.
Claimant is 1, 2, and 3.
Yes.
He represented. On what point are you challenging?
The tribunal says that there is breach of policy, my lord, on my.
Huh?
Breach of policy, my lord.
So why do you want the drivers?
They're all are made party, my lord.
Understood. Why do you need the drivers? The driver is in your favor. Then is there a stay? Stay. They've got the money.
The first appeared and
No. There's no, you have not asked for stay. Okay. So you pay that amount. I'm saying that you can go ahead and recover it from him. You can apply before that authority. We don't require the 5 and 7, we strike off. Why do you require 5 and 7? Huh?
They're not.
Not required. Who is 4?
My lord, honor of the other vehicle.
4 service done.
My lord,
4 service done. 4 service is over. 5 and 7 not required. You are appearing for 1, 2, and 3. Okay. Remove this 5 and 7. देखो कि तो आगे और तो ना Mr. A.K. Gupta. No, so it is seen from the office note dated 7/3/2000. Hang on. 19/12/24 that the service upon respondent number 5 and 7 is not complete. Full stop. Mr. So-and-so appears on behalf of the respondent numbers 1, 2, and 3. Full stop. It is also seen that the respondent number 4 and 6 service is complete. Full stop. 8 is what?
It is the,
Why you are not being able to serve the United area? Because there is no address. It is the address. Branch manager, United India Insurance Co. Limited, Guwahati. Done.
yes,
We strike off unnecessary without giving details we have given. So we strike off 8 because of that.
and that petition is, yes.
What? Where is the office? Now, isn't it there out there in the website everywhere? Then, so what we have done out here is filing an appeal, not ask for stay. Nothing can be done. We strike out respondent number 8. Why haven't you? Why are you making the branch manager as a party? Why not the company? Forget about the claim petition. Here, can you have it, the branch manager? Is he the person liable? The service, no, it is further seen that as regards the service upon the respondent number 8, the service upon the respondent number 5, 7, and 8 is not complete. Mr. A.K. Gupta submits that the names of the respondent number 5 and 7 may be struck off, taking into account that they are the drivers of both the vehicles in question. As regards the respondent number 8, he submits that taking into account that the address has not been properly mentioned, he would like to take fresh steps with it upon proper address. The learned counsel, is directed to take fresh steps upon the respondent number 8 by way of registered as well as usual within 7 days. Mr. So-and-so appearing on behalf of the respondent numbers 1, 2, and 3 submits that the award was passed on 18/7/2023, and the petitioner and the claimants have not received any amount. This court observes that the filing of an appeal does not amount to a stay of the execution, and taking into account that there is no application filed by the appellant herein seeking stay, the claimants, that is the respondent numbers 1, 2, and 3 shall be at liberty to proceed for execution of the award before the tribunal.
But one copy may be served.
Give it.
Obliged.
Yes. Service complete.
Respondent has appeared and recorded.
Service complete. We stood for hearing in the usual course. Liberty LCR received. He can appeal. Liberty given to both parties to file application. Right.
Hence.
Yeah, Your Lordship.
Yes, what is this?
Your Lordship here, 4 and 5, Your Lordship, newly impleted respondents, Your Lordship. I am praying for some more time to file our affidavit, Your Lordship.
For the respondent?
Yes, Your Lordship, 4 and 5. Newly impleted respondents, Your Lordship.
Number?
4 and 5, Your Lordship.
Commissioner. Transport and Commissioner Finance.
Yes, Your Lordship.
Yeah, I gave you time earlier.
Yes, Your Lordship. I am praying, Your Lordship, further some
Mr.
more time.
Counsel,
maybe
you have to
30 minutes.
understand. This
Yes, Your
court
Lordship.
doesn't give time. Once I have given time means time. Doesn't mean that it will happen like this.
Yes, Your Lordship. I understand. Your Lordship. That's why I am praying, Your Lordship, before Your Lordship.
If you don't file it, then we have to assume that whatever stand is being taken by the petitioner is right. Who is paying for the petitioner?
Your Lordship, one last opportunity may be given, Your Lordship, granted, Your Lordship. This is my humble, sincere request,
We'll
Your
have it
Lordship.
on 1st of May.
Yes, Your Lordship.
You have to file your affidavit by 25th of April.
Yes, Your Lordship.
Okay.
Yes, Your Lordship.
And if necessary, the petitioner will file the reply. Okay?
Yes, Your Lordship.
Mr. Arbasar. Arbasar.
Why Ram, Your Lordship?
Why the learned counsel appearing on behalf of the respondent number 4 and 5
Yes, Your Lordship.
submits that a final opportunity may be granted for the said affidavit respondents to bring on record their stand by filing an affidavit in opposition. It is noticed that by an order dated 11/2/2025, the respondent number 4 and 5 were directed to file affidavit on or before 23/2025. However, the said affidavit has not been filed. So taking into account the exceptional grounds stated by the learned counsel appearing on behalf of the respondent number 4 and 5, this court grants a final opportunity to the respondent number 4 and 5 to file their affidavit on or before 25th of April 2025. The petitioner, if so advised, would be at liberty to file their reply. List the matter again on 8th of May 2025 to be taken up at 2 p.m. through the video conferencing mode.
Obliged, Your Lordship.
Deeply obliged.
Interim order is there, some order is there, something.
No interview, Your Lordship. Obliged, Your Lordship.
Obliged.
In
Timing item 49.
I have contacted my client, who's dealing with me. He stated the name of the advocate, 3 advocates are there, but he doesn't get the enrollment number. The enrollment number he has not kept.
what is the name?
Pranesh Roy, Abhishek Chakraborty, and
What Chakraborty?
Abhishek Chakraborty, and Vikas Prasad.
Vikas Prasad.
Prasad.
E.
PI.
I'll impose them 25,000 cost and allow them to file because it's the fault. I've seen it. It's the fault of the council. Absolutely, it's a call for, and they have already filed their counterclaim written statement. So let it be taken on record, but subject to deposit of 25,000. And also that these are the 3 persons who are the culprits for this problem. So the bar council, I'm referring it to. এই না অর্ডাৰটো এই আগৰখিনিলৈকে থাকিব হা কোনে লিখে আছে তুমি লিখিছা না 1,000 cost thereby fixing so and so for filing it. Thereupon on demand as the plaintiff did not file the written statement, the learned trial court had passed an order for proceeding with the suit, thereby rejecting the prayer for adjournment for filing of the written statement. Stop. written statement লিখিলে তাৰপিছত তুমি নালাগে না was only on 14/6/2004 that the plaintiff filed a written statement against the county saying to accept the written statement. This petition was rejected by an order dated Iman assigning reasons dated Iman by the learned trial court, which is impugned in the instant proceedings. I've heard Mr. S. Decker, the learned counsel appearing on behalf of the petitioner, and Ms. S. Saikia, the learned counsel appearing on behalf of the respondents, and have given my anxious consideration to the respective submissions. This court have also perused the materials on record. From the materials on record, it is seen that the plaintiff had filed the suit seeking partition of the suit property described in the plaint. The respondents herein, who are the defendants, had filed a written statement the counterclaim was also filed separately by the defendant numbers 1 to 4. The said counterclaim was filed on 14/11/2023, isn't it?
16/11.
15/11/2023. From the order sheet enclosed to the instant petition, more particularly in Lecture 5, it is seen that the learned trial court, 16/11/2023, filed a counterclaim on 16/11/2000. From the order sheet enclosed to the petition to the instant proceedings, it is seen order sheet of the trial court enclosed to the instant proceedings. It is seen that the learned trial court, taking note of the fact that the defendants have filed their written statement along with their counterclaim, fixed 16/12/2023 for filing of the written statement against the counterclaim. It is further noticed that from the orders dated 16/12/2023 and 24/1/2024, that the copies of the written statement as well as the counterclaim was not received by the plaintiff. It is relevant to take note of that the plaintiff was represented by the counsel, and it was the duty of the counsel to have received the said the counter written statement as well as the counterclaim, and bring it to the notice of the plaintiff. It is further seen that only on 26/2/2024, a petition was filed on behalf of the plaintiff. That some documents are required for filing the written statement against the counterclaim. Therefore, from a conjoint reading of the orders passed on 16/11/2023, 16/12/2023, and 24/1/2024, and 26/2/2024, it would show that the counsels who was represented, the learned counsels who had represented the plaintiff in the suit did not receive the counterclaim. Till 24/1/2024. It is the duty, as stated above, in this respect, this court further finds it relevant to take note of Order 8, Rule 6A4. 4, na?
4.
Which stipulates that the provisions that the counterclaim shall be treated as a plaint and governed by the rules applicable to the plaint. This court further finds it relevant to take note of Order 8, Rule 6G, which stipulates that the rules relating to written statement by a defendant shall apply to a written statement filed in answer to a counterclaim. Therefore, the provisions of Order 8, Rule 1 would apply insofar as filing of the written statement against the counterclaim. In the backdrop of the above, if this court takes note of the order sheet of the learned trial court, it will be seen that till 24/1/2024, the plaintiff was not aware of filing of any counterclaim. And it was on the fault of the counsel appearing on behalf of the plaintiff that the plaintiff had to have been saddled with the order dated 11/3/2024, thereby rejecting time to file the written statement to the counterclaim. Further to that, a perusal of the orders dated 26/2024, 4/3/2024, as well as 11/3/2024 appears that even after committing such a mistake by the counsels who was representing the plaintiff, they did not care to take urgent steps In fact, the order dated 11/3/2024 further speaks in the manner in which the counsel appearing on behalf of the respondent plaintiff was conducting the suit. He was even not present. On 11/3/2024, in spite of the fact that by the order dated 4/3/2024, a last chance was given along with cost of rupees 1,000. Next. It seems the counsel for the plaintiff woke up only when the order dated 11/3/2024 was passed. And thereupon, on 14/6/2024, filed their written statement to the counterclaim along with a prayer for accepting the written statement to the counterclaim and deposited the cost of rupees 1,000. It is a right principle of law that on account of the fault of the counsel, the party should not suffer. And the present case is a glaring example as to how the counsels of the plaintiff have taken the plaintiff for a ride and have betrayed the trust of the plaintiff reposed upon them. During the course of the hearing, this court wanted to know as to who are the counsels who had led to who were the counsels for whose negligence and faults the plaintiff had to endure this difficulty. Mr. S. Dekar, the learned counsel, submitted that there were three counsels who were appearing on behalf of the plaintiff. They were Sri Pranesh Roy, Sri Abhishek Chakraborty, and Sri Vikas Prasad. Proceed. Taking into account the fault on the part of the plaintiff on the counsel, which the learned trial court ought to have taken note of, as was apparent from the order sheet itself. It is the opinion of this court that the learned trial court ought to have accepted the written statement filed by the counterclaimant, filed by the plaintiff. In that view of the matter, this court interferes with the order dated 14/8/2024. Next. This court cannot also be unmindful of the fact that on account of the plaintiff, as well as the plaintiff, as well as her counsels, her counsels, the defendants have been subjected to undue harassment. It is the opinion of this court that some form of compensation requires to be paid. Accordingly, this court imposes a cost of rupees 25,000 upon the plaintiff. Which shall have to be deposited by the plaintiff before the learned trial court. On the next date, so fixed herein below, hereinafter. It is further observed that the deposit of this amount of rupees 25,000 shall be a condition precedent for acceptance of the counterclaim, written statement to the counterclaim by the plaintiff. This court further takes note of that by an order dated 2010-2014-24, the further proceedings of title suit number 60/2023 was stayed. The said stay order stands vacated, and the parties are directed to appear before the learned trial court on 22nd of April 2025. This court further observes and directs that upon deposit of the amount of rupees 25,000 on the next date so fixed, that is 22nd of April 2025, the learned trial court shall accept the counterclaim, a written statement to the counterclaim, and proceed with the suit. This court, before parting with the record, this court observes that the plaintiff herein would be at liberty to take steps against the above mentioned counsels, as well as realize the same by filing appropriate applications if so advised. Oh, I will only give you the defendant would be at liberty to file application before the learned trial court for release of the said amount, and the learned trial court shall pass appropriate orders.
Order item
Trial
24.
court should also maintain a black book of these lawyers.
Wait, please, Your Lordship.
What is this? The same type.
Lordship, the petition for filing written statement was rejected, my lord. Which is the case of proceeding.
We have it on that date. Same issue. Isn't that the same issue?
So,
Oh, this is different.
Lordship may kindly see page number 39.
What happened? Other side is not appearing?
Their names have been shown in the cause list.
They're not appearing. Hello, some other day, but this is to be allowed. He therefore submitted that the order as well as the so and so ought to be interfered with, taking into account that the claimant has only proceeded against demand and not against the petition. But state the proceedings, yes. You wanted to vacate that area. Why is the other side not representing? Services, yes, somebody has. Nobody has.
Their names have been shown in the cause list today.
Okay. None has appeared on behalf of the respondents in spite of their names have been reflected in the cause list. First, list this matter again on 28th of May 2025. First, it is observed if the respondent is not represented on the next date, this court shall proceed to dispose of the matter on the basis of the materials and shall proceed to dispose in their absence. Because the interim order passed earlier shall continue till then.
Much obliged.
Where is the petitioner? He is there. Execution.
Page number 17.
And appears on behalf of the petitioner on call. You are appearing for everybody?
Yes, Lordship, only one, but it's only one respondent.
1, 2, and 3. 2 and 3 is performer. You are appearing for 1, nah?
41,
This is pertaining to eviction.
eviction.
What is it challenging?
The page number 70, Lordship. Getting class possession.
Equity holder paying for getting vacant possession to share within the area of the schedule of the execution. And then what is wrong with this order? What is wrong with this order?
They haven't mentioned anything in the ground also, Lordship.
Nothing wrong. As per order 21 rule 41, within 2 years it can be done.
Exactly, Lordship. They are not on delay part. They are on the part of this demolition of the structure.
It will be demolished.
They have not been demolished because of the stay order.
Oh, we vacate it. This type of matter means what is there to stay? Order is right. They have to file. Have they filed any application before the executing court?
This application was filed, that application was the annexion number 8, Lordship,
What did they file?
the application.
Application. No, this is your application.
Yes, this is my application.
Have they filed any
No,
application?
they
there?
haven't filed any application.
Then what is there? They have to file.
They haven't filed any application.
My goodness, how can there be a stay? Let us see what is the ground on which this court have stayed. Submits that as
Court
per the
file grounds
case
are there,
status in here, the
ABC.
court case was fixed on here by the has passed the order on Iman. Behind the back of the petition and such the impugnant. But the impugned order has directed suance. What is this case status? How can it be fixed on 18/7/2024?
They've annexed that one, Lordship.
Huh?
It's at annexion number 9.
They've enclosed
Enclosed, Lordship, page number 67.
page.
67.
7. Can this be the ground?
The sole ground, because even they did not file any application with regard to that.
Oh, no, this can't be a ground. And the order was passed when? No, what is this order date? 15/7/2024.
Yes.
Should be 24. Order is wrong date, I suppose.
Yes, it has been wrongly mentioned, 23 mentioned. In the prayer portion, they mentioned it 15/7/24. Case number 5/24.
15/7. Here, notice has not been issued.
Nothing has been issued.
Then where is the question of this?
But there is no such ground in the petition law. The only thing is that in the, this, page
And
number
what is this
67 and
account?
9,
Why account balance is shown?
18/7/24. Account balance has no relevance with this order law. Account balance has no relevance. Something has been paid and all these things, the construction has been made by the judgment debtors. So in that.
Here they approached them,
Yes,
the
sir.
court, the trial court.
Exactly. Lord.
Hello, none appears on behalf of the petitioner on call. Mr. So-and-so appears on behalf of the respondent number 1. This is an application filed under Article 2 to 7 of the Constitution challenging the order dated 15/7/2023. Bracketed लिखिबो. The 15/7/2024 bracketed लिखिबो wrongly written as 15/7/2023. Passed by the learned civil judge junior division number 2 Karimganj in title execution case number 5/2024, whereby the civil Nazir was directed to ensure the execution proceedings as per the order. Full stop. It is seen from the materials on record that on 3rd of 8th, the execution proceedings being title execution case number 1 or 9. What is the number?
Title execution case number allotted here in page number
5.
Execution case number 5/2020.
5/2024 was filed by the respondent herein, who was the decree holder, on 3/6/2024. Seeking execution of the judgment and decree dated
Yes, Lord. Judgment and decree dated 5.
30/3/2023, passed in title suit number 120/2016. It is further seen that the learned trial court, learned executing court, by the impugned order dated 15/7/2024, taking into account that the execution proceedings was filed within a period of 2 years from the date of passing of the final decree, directed the civil Nazir to proceed with the execution proceedings, thereby fixing 31/8/2024 for report. The petitioner herein, who is the judgment debtor, the other judgment debtor, na,
Yes, Lord. Definitely.
have not filed any application before the learned executing court and have approached this court on grounds which is completely unfounded. Considering the above, this court finds no ground to interfere, exercise its supervisory jurisdiction against the against the order dated 15/7/2024. Wrongly written as 15/7/2023 in title execution case number 5/2024. Accordingly, the instant petition stands dismissed. The interim order stands vacated. And the learned executing court, that is the court of the civil judge, junior division number 2, Karimganj, shall proceed with title execution case number 5/2024. In accordance with law. Before parting with the record, this court, however, finds it relevant to put a note that the learned executing court ought to have been more careful in putting the date in its order sheet.
26.
My lord, I seek your indulgence. The item number 20 is concerned.
20.
20.
What happened?
Your lordship. So, that are fixed for usual court, my lord, but it is in interim prayer, my lord, interim IA. I am the applicant, my lord, applicant has been admitted, my lord, but it's not report. And my lord, I appeal for status quo, my lord. I am in possession of the two claims. IA number, my lord, 277/2022. Earlier occasion, my lord, this is not report, was pleased to issue notice, my lord. And other side has appeared, my lord. And in spite of their name showing, so we are not appearing.
In spite of name showing, where were you?
Lord, as soon as I.
Where were you?
Lord,
How many names of counsel for the appellant is being shown? Only one.
no, my.
Then where
My lord,
were
as
the
soon as I
other?
entered, my lord,
We'll consider your prayer. We'll consider your prayer as the last item of the day, provided it reaches.
My.
With however cost. Cost upon you. Yes, what is that? 25, 26, huh?
26.
What is that matter? Very challenging. What are you challenging?
Yes. Review petition, challenging the order of the civil judge junior division.
Redemarcation of the land on the ground that the demarcation was not done as directed by the court. Lanaka has filed written objection to the petition. Peru so and so. Now, once there was a demarcation done, okay, now what happened? Did you put an objection? Then
No objection, Lord.
then
Moreover, Lordship, after that is the demarcation by order dated 12/5/2022, Annexure 5 of their petition, that order has not been challenged anywhere. So that order has been, that demarcation has been accepted by the
accepted.
Lord.
Then
12/5/2022, no challenge. They are filing the IO against the redemarcation order, against the redemarcation order which has been filed by the. Still there is 12/5/2022.
So the learned counsel appearing on behalf of the petition.
We are newly engaged in that.
You don't need to be furthermore engaged. These type of matters cannot remain. Unnecessary matters. Some kind people have issued notice in this case. I have not have issued, they just stay, no stay. But what happened?
Okay,
Suit
please.
disposed. Suit disposed.
Disposed of. Maybe disposed.
The suit is disposed.
No, suit is not disposed, but this is an argument stage.
There's no
Because
stay.
after filing the title appeal, suit has been remanded back to the municip again. With a direction that it has to be redemarcated. And accordingly, Lat Mondal redemarcated and report has been submitted to circle officer. Circle officer submitted the report to the municip. And by order dated 12/5/2022, in except 5 of their petition, that report has been accepted. They are not challenging the order of the municip dated 12/5/2022.
Page.
Page Lordship.
Accepted. Next are 5. As directed by the honorable judge, title both sides are given opposite to adduce for their evidence. The report of demarcation is accepted. Okay. And when this report of demarcation was given, they did not file any application for
objection has been- because
cross-examination, nothing.
both the parties were heard by the municipal.
This
On
regard
the
report
report,
and accepted,
that has been accepted.
and they did not challenge that.
That they did not challenge it. Again, after when the matter is fixed for argument, they filed a application for demarcation that has been rejected. That is Lordship.
Lordship, please come to the please page number 57. Here the learned district judge directed the matter that demarcated has the help of the field survey by causing cadastral map. But when the authorized person of circle officer has been examined, cross-examined, here in the page number 70, in cross-examination, he stated that the pinpoint to the তপশিলৰ it is in vernacular language. তপশিলৰ মাটি সহকাৰে সম্পূৰ্ণ মাটি প্লেন্টৰ জোখমাখ মতে কৰা হৈছিল ৰেকৰ্ড মতে দেখা নাযায় মই জনামতে পিন পইণ্টৰ পৰা জোখমাখ কৰিলেহে মাটিৰ একজাক্ট লোকেশ্যন জানিব পৰা যায় দেন ইয়াত আৰু পিন পইণ্টৰ পৰা জোখমাখ নকৰিলে জোখৰ মাটিৰ পৰিমাণত ভুল হ'ব পাৰে then we file an application for
When did you cross-examine him? 13/12/2022. Isn't it?
then we file
And when was it received?
In the
It was accepted on 12/5/2022. Then you cross-examine.
when we need newly engaged.
Then, very well. Then what happened? What did you do all this while? When did you file this application for redemarcation?
We filed this application lastly on 7/8. Sorry,
Immediately, 12/1/2023.
12/5.
Lordship, regarding cross-examination, there is a misrepresentation of fact before it's on our book. Because in the cross-examination, they have put question regarding the demarcation in 2006. But here the demarcation has been conducted in 15/3/2020. So the cross-examination, from the cross-examination, it is not reflected whether they directly put question regarding the recent demarcation which is made by the Lat Mondal Lordship. And moreover, in the Lat Mondal report, it has been reflected that the demarcation has been conducted with the help of the cadastral map laws. And it is also reflected in the order of the municip on the order passed on
Who was cross-examined?
process by the lordship at the
No,
time,
who was cross-examined?
the Lat Mondal Lordship.
Lat Mondal. And who made the survey?
Lat Mondal Lordship.
Lat Mondal. He himself did it.
Lat Mondal, that is completed the demarcation process, and that report has been submitted to circle officer. And notice has been issued to the circle officer for re-examination of the Lat. But from the cross-examination, which is contained in the vernacular, it is not clear that whether that particular question regarding using the cadastral map in relating to the recent, that is the recent demarcation, or regarding the issue of the previous, because there is a exhibit D, it is dated in the course on 25/2006. And in the order of in 77 page, it has been reflected that demarcation process has been completed through cadastral map, page 77, order of the municip. 7/8/2024, which has been changed before your watch.
It was done. This is the finding of fact. Arrived at. It also appears from the demarcation report that the demarcation was done using cadastral map as direction by the Honorable District.
But when we cross-examine the.
So you take this plea in the appeal if it goes against you. Why you are now doing it? If I dismiss your petition now, you're finished. You can challenge this order under 105 if you file an appeal. If the appeal goes against, suit goes against you, you file an appeal. Take this as a ground there. That it is not
The
being
main
done.
case is remand back due to. for
Understood,
conduct-
whatever may be. Are you not the defendant? Are you the defendant or the plaintiff?
the defendant.
So better off, na? Again get it remanded. You see, these type of things, if I pass an order, no, this is okay, you're finished. You can't take that as a ground under 105. You can very well later on, you can argue this, that cadastral map has not been taken and whatever may be. You can keep on arguing and then take it as a ground of objection in appeal. Again, it will be remanded, you remain there. Isn't it? Don't fight this. You say that you will take, if it goes against you, you will take it as a ground on the 105. It's the best. Certain cases you should never challenge it out here. The moment I challenge it now, if I pass an order dismissing this, you finished. This order gets finality. The first appellate court cannot touch it. Get the point. If you are always there in possession, try to have these loopholes. Ask Mr. Gupta, he's very expert in that. Isn't it? I have heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Submits that go from the evidence in the court, evidence, and he submits that in terms of the evidence of the Lakmanda, it appears that the cadastral map was not taken into consideration, but the same being a subject matter of the suit presently, which is yet to be argued. And if the yet to be argued, he would not he would not press the instant proceedings. He, however, submits that non-pressing of the instant petition could not affect the petitioner in the circumstance the suit is decided against him or prejudice his grounds of objection to be taken under section 105 of the Code of Civil Procedure. Taking into account the above, the instant proceeding stands closed on withdrawal. Full stop. It is observed that the withdrawal of the instant petition shall not prejudice the petitioner in the suit, as well as also in taking taking such grounds of objection in an appeal, if filed in an appeal. Grounds of objection, if an appeal is required to be filed by the petitioner. Wait. It is also seen, but there is no stay, na? There is no stay. In that case, accordingly, so it is this court, therefore, Any date fixed? Any idea?
25, 4.
So it has been submitted by the learned counsels appearing on behalf of parties that the next date is fixed before the learned trial court on 25/4/2025. The trial court shall proceed with the disposal of the suit in the present.
All right.
27.
Here's what is this?
This case,
Engraving.
Lordship, the respondents have filed one land grabbing. So, yes, so we are actually co-patagar. We are co-patagar. Our ancestral name appears in the Patta law of 1935. Also presently one circle officer report is there.
What do you want?
I have challenged the interim order at case 46.
What order?
Aid interim relief was granted, in which on the very first day ex party, next on order, aid interim, they have given the main relief of the suit.
You've given an injunction order?
Yes.
Where is that? Order.
Case 46.
Eight?
Case 46.
6. Is the order passed? Hereby ordered that the officer in charge to enforce serve the settlement matter of the case and have obtaining the opinion of Tell me, how does the court pass this type of order for the first day without hearing on the other side?
Since they have a
Court could have said they maintain status quo as regards the possession. But could the court have asked without hearing them? Say that okay, don't allow him to enter and even direct the police on the first date. What type of order these type of orders are passed?
But they have damaged the boundary fencing.
Understood, but first of all, how can the court on the first day direct them not to enter without knowing actually what is the fact? They have not done anything. Have they replied? I would have understood after seeing everything the court comes to an opinion. But it's a one-sided story, isn't it?
Okay, actually, altogether there is 5 bigger 7 kattha of land between them and us. Partition never had. So instead of filing partition, so they filed land grabbing case. And where we have domicile, Pakka house, we are living there. How can we land there? We don't even come under the definition of land. Because we have co-pattaga. And now circle of the report very much clarified.
And the matter is pending.
Matter is pending at evidence stage for PW.
No, this injunction is given. What happened thereafter?
Stay order was given by the Honorable High Court.
This court has
Yeah.
stayed it.
Yes.
A good stay. Type of orders are not expected. But the injunction proceeding is pending. Okay. We do one thing. As the injunction proceeding is pending, this court should not have both. So let this matter be, this order passed by this court shall continue till the disposal of the injunction proceedings. The court shall decide without being influenced by this.
The injunction proceeding may be decided within a time.
Certificate. From the date you give the certificate.
15 May is fixed.
Eh?
15 May is fixed for land grabbing case.
That is the
15 May, have you filed your reply
Yes, yes.
in the injunction?
After filing reply, they have issued.
The present proceedings under Article 2 to 7 of the Constitution have been invoked, have been filed, challenging an order dated 30/9/2024, passed by the learned additional district judge in Sukia in Ms. J case number 24/2024, arising out of land grabbing case number 12/2024, under the Assam Land Grabbing Prohibition Act 2010. This court have duly taken note of the order dated 13/9/2024, which is an ex parte ad interim temporary injunction order. The said injunction application being Ms. case number 24/2024 is still pending before the learned court of the additional district judge Tinsukia. Taking into account that there is already an injunction proceedings pending before the learned additional district judge Tinsukia, it would not be proper on the part of this court to maintain a parallel injunction proceedings before the parallel injunction proceedings. This court, however, further takes note of that by the order dated 28/10/2024, the impugned order dated 39/2024 was stayed. Taking into account that the injunction proceedings are pending, this court directs that the order dated 28/10/2024 staying the order dated 39, impugned order dated 39/2024 passed in Ms. case number 24/2024 shall continue till the disposal of Ms. case number 24/2024. So it has been further mentioned by both the councils appearing on behalf of the parties that in the meantime that the next date is fixed before the court of the additional district judge Tinsukia on 15th May 2025. This court observes and directs the learned court of the additional district judge Tinsukia to dispose of the Ms. case number 24/2024 at the earliest and preferably within 1 month from 15/5/2025.
That date is fixed in the suit. It's a case, no date is fixed. That is the state.
That is why I'm giving the date. You want to appear before? No, wait. It has been submitted by the learned councils appearing on behalf of the parties that in view of the order passed by this court, in view of the present proceedings, the learned court of the additional district judge Tinsukia have not further fixed any date in Ms. case number 24/24. Mr. A.K. Gupta appearing on behalf of the respondents, who is the complainant in the said proceedings, land grabbing proceedings, submits that there is an urgency in the matter. Taking into account the above, this court directs both the parties to appear on 9th of April 2025 before the learned court of the additional district judge Tinsukia. On the said date, the said court shall fix a date for hearing as per the business of the court, taking into account the business of the court, and dispose of the said injunction proceedings being Ms. case number 24/24 as expeditiously as possible and preferably within 1 month from 9/4/2025. Is it possible? The order of stay as already observed above, the order dated 30/9/2024 passed in Ms. case number 24/24 shall continue till the disposal of such.
May it please your lordship. Your lordship, may Parol's office note dated 18/3/2025. Your lordship, services not completed in respect of respondent number 5.
With 5,
Respondent number 5 is the owner, your lordship, owner of the vehicle insured by us.
you are the
Lordship.
What are you challenging on?
Liability, your lordship. There were two vehicles involved and we are given the sole liability, your lordship.
Huh?
There were two vehicles involved in the accident. One is the truck and the other is the bus insured by us. And the sole liability was given of us.
On the ground of contributory negligence.
Liability was given on us, your lordship, and we are challenging that.
So your case is on contributory negligence. Now, if it is on contributory negligence, why do you need the owner then?
Number 5. Yes, sir.
Then?
Other, in respect of respondent number 124, their also report is not available, your lordship. They are the claimants.
1 to 4 you are paying for?
6, sir. This one number 6, sir.
Who is he?
One of the
Owner
owner.
of the truck.
Claimant not service complete.
Not available.
Okay. Taking into account that the service is not complete, list the matter again on 28th of May 2025. Full-stop. The registry shall give an update as regards the service upon the respondents.
29. It is not. My lord, this is a regular second appeal, my lord. Otherwise, appeal has been admitted, my lord. And respondent number 1, 3, 4, 1, 2, 4, and 5 have appeared, my lord. On the earlier occasion, my lord, it was informed that respondent number 3 had died. So I took instruction, my lord. As per my instruction, my lord, the respondent number 3, that is the plaintiff number 3, we are the defendants, my lord, had died in the year 2015 during the pendency of the suit. So if this instruction is correct, my lord, then that suit is abated against the plaintiff, my lord, particular plaintiff.
Plaintiff,
I am the, where the plaintiff here.
when did the plaintiff number 3 die? Produce the death certificate of the plaintiff number 3.
I could get
I'll
this.
take it.
What is this?
That certificate is by proportional.
Valid by way of an affidavit.
I will also take it.
Yes,
I will take it.
It has been submitted that the plaintiff number 3, who is the respondent number 3 in the instant appeal, expired on 1/8/2015 when the suit was still pending. Mr. J. Ahmed, who appears on behalf of the respondents, herein respondents number 1, 2, and 4, 4 and 5, who were also the co-plaintiffs, is directed to place before this court on the next date. As regards when the plaintiff number 3 expired, list this matter again on 26th of May 2025. You file an additional affidavit.
regarding the I,
But he is continuing.
stay, my lord, that, stay, my lord, is still pending, not passed. I.
Who submitted this? The appealant for the opposing party submitted that he had been informed that during the pendency of the appeal, respondent number 3 had expired. Mr. Ahmed, why did you make that submission if it is, he died at the time when the suit was pending?
I got inspection.
You can't get this type of instructions and tell it before this court. You have to be more responsible. You are exercising a right power under Order 22, Rule 10A. Don't you think that you have to be more responsible? If this person has died in the time when the suit was pending, why did you make a statement before the court that during the pendency of the appeal he had died? What? Do you think this Order 22 Rule 10A is such a simple thing? Recently, there is a judgment of This is Dipankar. Wherein he duly refers as regards Order 22 Rule 10A. Seems to be a very responsible submission, Mr. J. Ahmed. What is this? I for?
Okay.
Huh?
Execution is still pending, madam. Title execution number 81 of 2021.
Okay. And the appeal has been admitted. Okay, this is an application filed under Order 41 Rule 5 for stay of the judgment and decree dated 22/4/2021, passed by the learned. What are you asking for stay for? For judgment and decree dated, stay of the judgment and decree dated 19/2/2024, passed by the learned civil judge, senior division, Borpeta, in title appeal number 11/2021. Taking into account that the accompanying appeal has already been admitted by formulating of substantial question of law. It is the opinion of this court that this court is of the opinion that till the disposal of the accompanying appeal, the impugned judgment and decree dated 12/19/2024 passed in title appeal number 11/2021 by the learned civil judge, senior division, Borpeta, is required to be stayed. Accordingly, the judgment and decree dated so and so passed by so and so shall remain stayed till the disposal of the appeal. I extend this.
Hello.
30.
You file an affidavit, huh?
If your lordship.
Oh, what is this?
The I has been filing, praying for modification of your lordship judgment and order, my.
Why?
Under the
What have I
lordship,
done?
Judgment your lordship in date, my lord, April 13, the relevant person. The writ petition was filed, my lord, as a demarcation case was not decided for a pretty long time. And your lordship, my lord, I directed, if your lordship comes to page 16, my lord, directed demarcation.
Hmm.
I read that.
And circulate.
Paragraph 5, my lord. At the
Within 3 months, it has to be done. Why you're not filing contempt?
So, my lord, they had gone there. The revenue softener, after giving many adjournments on the, my lord, request of the other side, they had gone there and said, this is your land from that tree to that tree. No demarcating anything like that.
And they will have to give you a minutes. Have they given you?
No, my lord, the report has not been.
File the contempt. Let this remain. File a contempt, we'll take it up. Because once you file a contempt, now we'll take up this issue. Provided it comes back to me.
Because they have to file a report and they'll say that we have gone there and demarcated. No matter how it has been demarcated, because they have
Well,
gone
they
there.
have to show, na, on the basis of the demarcation carried out, so yeah, prepare a minutes and duly circulate with the petitioner as well as the respondent number 5. Then, so that has to be done. You file a contempt, we'll see. It's a matter of, when are we filing it? You file it immediately, this will, then you have to take along the contempt with this. Then only it will come before me. Then I will take it up. Okay? It's the matter.
Tuesday, I'll be filing on Monday.
I won't be here, but you file it. I'll take it along, list the matter again on 23rd of April 2025. In the meantime, you get it and take this with this.
31.
What is this?
My lord, this is my second appeal under the provisions of RERA. Your lordship was pleased to formulate the substantial question of law on the last occasion. If I may read the last order here. Your lordship has formulated a question as such as to whether the RERA had the jurisdiction to decide the complaint in the present facts of the case, more so on the basis of the findings arrived at by the learned appellate tribunal, that the appellant was not required to be registered under the RERA Real Estate Regulation Act 2016 in respect to the project.
Now, why the matters come? LCR has not been received. That is the
LCR has
reason
not been
why.
received.
LCR having not been received, the registry shall call for shall ensure that the rate. It is seen that from the office note dated 5/3/2025 that the LCR has not been received. This appeal on 7th of May 2025. The registry shall take appropriate steps for requisitioning of the LCR.
Just one more submission is there, my lord. There was a stay order against the realization of the amount which was deposited before the appellate tribunal. That has been realized, disbursed by the respondent.
In spite of
Before
the
the
stay,
No, my lord, that was taken up before this stay order had come up.
Before
We
the,
had filed
respondent had disbursed the amount
prior to that,
prior to that.
so what to do?
So they given at least undertaking that to be deposited in the as a security deposit before this court.
Why?
Or maybe given an undertaking, my lord.
They have already deposited, the order has become infructuous.
Unless there's a submission that is subject to the
You
outcome.
see, if you win the case, you'll get back the money.
32.
But IA এখন আছে নাকি? Just 1 minute. Where did I pass the stay order? In the main appeal or in the IA?
There was an IA. IA is civil 177/2025.
Oh, it has been disposed of.
Yes.
In disposal of the prisoner according to the directions contained in paragraph 23 of the judgment is state till the disposal of the appeal. এই আগর এই মেইন টু অর্ডার টু এখন লাগে এখন অর্ডার লিখে দিব Mr. A.K. Sahiwala, the learned council submits that the amount of rupees 10,57,000
57.
have already been disbursed prior to the order passed by this court on 5/2/2025. Taking into account the above, the order prior to the, he therefore submits that this court observes that as the amount has already been disbursed, amount of rupees 10,57,000 have already been disbursed to the respondent. Comma. This any the outcome of the instant appeal. And then this court, the disbursed by to the respondent, comma, it is observed that as to whether the appellant herein would be entitled to realization of the said amount from the respondents would be the subject matter, would be subject to the outcome of the.
Agreed.
Yeah, earlier occasion allowed the petitioner to take step, my lord, in 3 modes, my lord, upon sole respondent. Accordingly, steps were taken, but dusty service, he refused, by.
So did you file your affidavit?
Yes, but today morning I have filed my.
Has it come? Will you be writing it? And the other 2 steps you have taken?
Taken, immediately taken.
The affidavit of Dusty have not yet been brought on record. So it is also seen that the service report, service by way of registered as well as usual is not complete. Taking into account the above, list this matter on 26th of May 2025. The interim order passed on 7/3/2025 shall continue till then.
Diploma.
33.
I filed an affidavit to the effect that the incomplete set of memo 15 has been served on the respondents. Incomplete set of memo 15 has been served on the respondent.
Read.
I find an affidavit.
My lord, what had happened? Day before yesterday, this aspect was pointed out. Then yesterday, we wanted to serve the copy, they refused.
So the
Anyway, my lord, just now we are giving all the copies. Costa copy as an These are the 10 copies. Only few pages were missing below. Therefore, yesterday when we said, they said we'll take it, but yesterday they refused, then we found that they have filed this affidavit.
Tell me one thing, you have seen the impugned order.
yes, ma'am.
How can there be an impugned order in respect to a property which does not exist?
But that I will explain because I have.
Forget about the memo of appeal, I'm asking you how. You have seen the impugned order. Impugned order, I think Mr. Chaudhary's client must have given.
Impugned order has been given, but the
And you
annexures.
must have heard of them. Forget about the other annexures. We are not concerned. Only asking you. The impugned order having been, you have,
I have a copy.
how there can be an injunction order being passed in respect to a property which does not exist?
Well, that point was not objected.
Whatever that is not there. I am here to object. I'm asking you, simple question. How schedule A to J of the suit remains one? Secondly, when did I direct not to disburse?
That is.
Then the
And-
order
but
on the
but
face of
but
it is
the
wrong.
fact is also that
Third, did you implead, did you amend your plaint?
the prime dispute is with the constitution of the society, man. The constitution of the society. Respondent, the petitioner.
But where is the question of first? Therefore, I'm saying a trial court can very well take into account some certain subsequent events, but it is dependent on bringing it in the suit, isn't it? Because your injunction application has to be in a suit. And if the suit does not contain there, did you amend that suit?
Did not. But in the application, injunction.
Again, I'm telling you, you know the CPC.
Well,
I don't need to tell you further, but tell me, how is it possible?
But
Tomorrow you may say many things in your plaint. Okay, the plaint remained as it is. After some time, something happened. He did not. He just gave an injunction. It's good because it starts with the word in a suit. Then, how is it possible this type of orders? Secondly, that property does not exist. That property goes there. So your injunction has to be only in respect to the money. Can't be on the basis of A, B, C, D or J because that doesn't remain. So it is the question of money that you are entitled to certain amounts. So you have to therefore say somewhere in the plaint that is not there again, coming back.
actually means that the property is still in possession of the respondent. Okay. The property is still in possession of the government has not taken over the properties.
Government has paid the amount.
So
Why?
that is.
No,
Government
money has been deposited because of this dispute. This has not been released.
Yeah.
But for this dispute, money would have been paid to us, everybody, including my learned friend's client.
Then
Money has been deposited.
money has
Like
been
with the
deposited. Now
collector's
who-
office.
money has been deposited in the court.
Collector, yes.
My
So-
lord,
So
I-
why, if you have a problem with that, why you're going with the pursuing with the suit? If you're entitled, who are you? You are a person who says that you have a claim over the property, over the proceeds of the property in view of the compensation. So when the money is being deposited out there, why you're proceeding with the suit? Why don't you go for apportionment?
we have already filed,
And how is this pending then? When a land has already been acquired, how can there be an injunction? This is the fourth ground.
my lord, it was passed in the,
How can there be a suit? Tell me. The suit cannot touch that property because that property has already been acquired.
the suit was filed in 2020, my lord, I explained.
Understood? Therefore, the suit has become infructuous. Doesn't it mean? And that too when you have already gone before for apportionment. Your only question is the money. Because if you don't find it, they will have to deposit it. Because otherwise, why you are asking the government to hold the 155 crores with them? 155 crores.
My lord, that instruction I will have because I don't know whether the money has been deposited or not. No, no, lordship, there's a lordship order is there. Lordship order is there. But landing question is still in our position.
Understood.
Whether the money has been deposited, there is no.
The state has
record.
been, the state is very benevolent. You know, welfare state, benevolence. State has a lot of money to give. But the only thing is, but they don't want the land also.
But
They will take over the land. One fine day you will be seen, your house will be thrown out.
there is nothing on record to show that the money has been deposited. I'll confirm that from.
Money has been deposited because that is what has been stated. That is why they wanted to withdraw the petition. Some of them have withdrawn and I passed that order in the case of Mr. Chaudhary's case.
Lordship's order dated at page 222, para 13. Please come to page 222, para 13. Taking into account that the award has already been passed and land now vests upon the state, petitioner's submittee herein would be entitled to the said amount. So Lordship has directed that for apportionment, there will be a proceeding.
Well, I
That's
will
all.
say, further say, understand that if an application is filed expressing disagreement in respect to the
Yes, yes.
apportionment, then in such a case, the collector, that would be the collector.
Yes,
District commissioner has to act in terms with 30, read with 31(2).
yes.
However, the same is only to be applied subject to the dispute being raised by filing an application
Yes.
under 12(1)(b). So therefore,
And
they
they
will
also
have to
made submission,
deposit.
they
The
will
moment you file that, they will have to deposit. So therefore, when you have already approached, your entire case is for the money, not for the land. Then what does the suit have? Nothing.
Well, I show from the record that this order was passed taking into consideration an order passed by the ROC, Register of Societies. And no meeting should be done by this society for renewal of their certificate.
But these are not subject matter of this suit.
These are the subject matter of the suit because
No. All these things will be decided there where you are born. See, you are concerned with the money. Do they fight there? What are you doing with the injunction? See, there are two ways out. I can very well say that the injunction is bad, taking into account the fourth ground on which you gave it just. Others will wear the. Will you fight out there before where you have filed it, where the apportionment will be there, notice will be issued, done anyway. Because you see, if they don't deposit it in the court, therefore I made it very clear to deposit. Because what happens, the state holds to the money. And if he keeps on holding to the money, the problem is there is no interest accruing. And then the moment, therefore, if you see the Indore municipal, that judgment of the
Yes, in those.
Justice Arun Mishra.
Ah.
Here he says that the moment it is deposited in the court, it will be taken that the amount has been given to you.
It will not accrue interest.
So therefore, once it is deposited, so the matter needs to be urgently taken up. If you are fighting out here, nothing is going to happen.
But if the matter LA cases were fixed on 11th of April, and I'm not quite sure whether the money has been deposited or
No,
not.
no, you have to show to the reference court that there is an order passed by this court.
It has
So
been
the amount has to be deposited because the government will be there. And if it is not there,
They
file a
will appear on
contempt.
11th. But
File a contempt. We'll take it up. Why you have not deposited?
after 11th of April money.
You find it out. But anyway, what to do?
Well, after 11th of April, we'll see what the government stand is in the LA cases.
Chalo. Government stand is different, but that is immaterial. This is the government stand out there.
In the order of the lordship,
If he has not, Mr. Chaudhary, your client is not appearing in that early case because he will be a part.
yes. We have, sir, copy.
we are appearing.
Appear and then take it up. Why they have not deposited? If they have deposited, then the thing is
That
different.
will take its place.
When do we fix it then?
Needed conflict to lordship.
Matter having been heard at length and taking into account that Mr. Adhor appearing on behalf of the respondent takes some instructions and wants to take abreast of the situation, wants to take certain instructions pertaining to the reference proceedings, which is fixed on 11/4/2025 before the reference court. It's this matter on 23rd of April 2025 for further hearing. If dispose it of on that,
But-
I put it at further hearing so that it comes to me.
Yes. Like,
No, please, your lordship. Lordship, we have taken steps upon the respondents.
Steps not taken.
Yes, we've taken
When
steps.
so and so appearing on behalf of the petitioner submits that steps have been taken yesterday upon the respondents by way of registered as well as usual to stop. What is the matter about?
We are challenging the order, rejecting the condemnation petition by MSCT Lakhimpur.
You are coming under, okay. List the matter after completion of service.
Okay.
35.
My lord, we have taken steps as per lordship's order. The justice service has been also sent, but yesterday the party went, but they could not trace him out. So 2 or 3 days may kindly be granted to file justice service affidavit.
Hmm?
The justice service affidavit we shall file, but it could not be at sir. Yesterday he went to the party's house, but they were not at home. So again, they will go, so sometime may be
That
granted.
is why did you? Anyways, ticket. The service having not been complete. List the matter again on 23rd of May 2025. The interim order passed on 7/3/2025 shall continue till then.
Of life.
36.
What is this?
Lordship, here, my lord, the step has been taken, my lord, but the office not reflects that the.
Oh, this one, same. So let's fix it on 29th.
Yes, ma'am.
Service, what about the service?
Lordship, investor respond number 1 and 2.
Sir, notice.
No such person could be found.
in the address.
In fact, Lordship, there are 2 addresses. One is permanent and present. So Lordship may allow me to take custody in both the addresses this time.
Mr. T. Kunte, appearing on behalf of the petitioner, submits that he would like to take service upon the respondent number 1 to 4 by way of the stick, printed to the registry of this court and file an affidavit of service. Taking into account the above, the for the petitioner is directed is given the liberty to, directly take some steps of the stick to the stick, rooted to the registry of this court and is the matter on 29th of May. Let's see,
Perhaps for
April.
Lordship, one submission, Lordship, 1 and 2, my lord. There are 2 addresses. Both the addresses may be allowed to.
Take it. Whichever it is, they are.
57.
There may not be, there is no report for service. Step have been taken,
This is same, na?
same, no?
37, 38 is same.
36 and 36,
Huh?
36 and 37, same matter. my lord.
Here you don't want to take the stick.
No, my lord. You can wait, my lord, because there is no report.
Okay, list this matter, taking into account that the service upon the respondent number 1 and 2 is not complete. List this matter again on 29th of April 2025. Registry shall give an update on the service.
Lordship, interim may continue in both the cases, my lord.
Same আগতে দিয়ে দিব, না?
Both the cases.
38.
Much.
What is this?
Service is complete in this case, Lordship, it is possible.
Oh, this case.
On behalf of full respondent.
What do you have to say?
Yeah, that's the duty of the.
They only receive. And the respondent is represented by so and so to submit sometime may be granted. At on 30th of May 2025, interim order passed earlier shall continue till then. Interim order dated 17 to 2025 shall continue.
Please, Lord.
39.
Step has taken, justice service has also been taken. Certificate has already been filed.
Oh, this one.
I would appear only for the plaintiff, who is the respondent number 1.
You're the main person
My lord, I am.
who have admitted
Yes.
he is the defendant.
And he's the plaintiff.
You are the,
I'm the defendant number 1.
so you want the admission,
Yes,
degree on admission
yes,
to be given to the plaintiff.
yes,
The plaintiff is opposing.
oh, yes. But only for the delay. Delay the matter.
The prayer, what he had admitted is that, my lord, there was total land of 2 kata 10 less, which is the ancestral land. 1/9 share for all the legal heirs. He admits that he is willing to give me the 1/9 share that I am entitled. That I am anyways entitled. But the issue is that he, as the defendant in this case, my lord, had entered into a development agreement for the entire 2 kata 10 lessons of land. And in my suit, one of the prayer is that the said agreement also has to be cancelled. It's not just about giving me my share, but then even if my share is given to me, I may not be willing to give it to the same developer.
Is it something like the brick on which I stand is mine?
That aspect is there, and I'm told that, my lord, the respondent number
4 and 7 hearing, they have filed a separate suit again. Initially. Questioning the very relinquishment. The degree might admission on admission might be difficult, my lord. Maybe a case where there is a settlement ultimately under order 23 rule to
Now, if you
application
get-
is made.
Have you entered into an agreement for the entire land?
Yes,
And why you want to give him one line?
actually, accept him, accept the plaintiff. And he did not talk with me when I approached him. But other than all the brothers have relinquishment.
No, no,
DW.
no, Mr. Bora, kindly tell me one thing. Out of this, have you given the development agreement for 2 kata 10 lecha?
Yes,
If you have given for 2 kata 10 lecha, does the 2 kata 10 lecha include his one line share?
that's why he filed it suit.
I'm asking you. Does that 2 kata 10 lecha include his one line share?
Yes. And actually, my one submission, the if partition case has already been filed before the revenue authority. That is pending.
So?
And the present petitioner, depending on is willing to give his share. There is no one. But as agreement has already been done with the builders, that's why he filed a suit. That's why he admitted everything. If even agreement for sale development cancel, there's no objection. But his share, he will give.
That is not there in his order 12 rule 6 petition.
Yes. You have to
He-
kindly,
he's cancelling the agreement.
kindly peruse the plan. His share. Kindly page number 34, schedule, PC1. Schedule C, he is entitled 5.5 leases. He is entitled to get 5.5 leases out of total land.
So you are agreeable to give him 5.5 lecha?
Yes.
Which he is entitled.
From which side he can take?
Now, schedule D, you are agreeable for cancellation of the deed of development.
I'm also agree.
Are these people party?
Yes,
You are having an agreement with somebody. Is he a party?
yes. In the suit, they have made party.
That development agreement person.
Yes, dependent number two.
Okay, does he agree to that
Yes.
for
He also-
cancellation?
He also,
Where is he? Has he filed a written
but
statement?
he also admitted. He also admitted by filing WS.
What did he say?
I have annexed this WS.
Now, what does he say? That person
Yes, he has no objection.
in cancellation.
Yes. And madam,
And what remains? Your relief is given. Once this is being done,
Basically, one might not even.
and
if
page
there
number
is a
43, page number 43 and exactly. Both the builders have filed WS, different number 2 and 3,
what is there?
page number 43.
Why don't you do one thing? You cancel the development agreement by yourself. There's no bar.
No, that will continue, that will,
Now, once you cancel it and then file a subsequent finished agreement for development is cancelled. And power of attorney, why are you asking the power of attorney to be cancelled? He did not give your power of attorney. Then what business you have?
That relief, of course, has to be, might not probably considered separately.
Huh?
That relief, of course, I may not be entitled. to it.
Absolutely
But
no.
as far
That
as
one.
my share is concerned, he was having no right to give a development agreement over my share.
That he is agreeable. He can very well go for cancellation, Mr. Bora.
yes.
Why you are not going for cancellation of development agreement and
No,
file
I'm
it?
ready to cancel.
Cancel it.
Yes.
Cancel it and
Yeah.
give it there.
If Lordship may pass a appropriate order, I
I'm not going to pass any order. You cancel it, bring it by way of an affidavit before this court. And Mr. Vibhas, you kindly take out your prayer of you are not interested with cancellation of the general power and finish up the matter. He is going to give you 5.5 lesser. No. Then you can very well go there. Unnecessary, why you are harassing father, son?
Yes.
Brothers.
All brothers, all brothers.
Then do something as you have too much of money. I
One
suppose.
of the brother is
No,
the
my lord,
London
there's a
advocate.
money.
Not you, he.
Yes, money is not matter, but the person who has retired from the Reserve Bank of India.
Who?
The present plaintiff. And his
Mr.
hard
Bora,
data is
Mr.
of
Bora,
government officer.
Reserve Bank is.
no, let us,
Money doesn't matter,
Mr.
but
Bora, let
because
us assume that he has resigned, he has retired from Reserve Bank. He doesn't mean money for himself.
Yes.
He means money for the country.
Actually, it's an egocentric matter.
Okay, let me fix this matter on some other day. You file, get it cancelled and bring it. And you give up this deed. The general power. And then we can ask on the basis of that, I place it before the trial court and the trial court to pass some judgment on decree taking into that. This is how it is to be done. But you just bring it.
Also, then there can be
I'm-
an order
I-
under order 23.
Huh?
There can be a decree on settlement.
Compromise.
being-
Why you are not filing a decree on compromise?
It's better in.
No, actually, I'm the defendant.
Understood. He is also agreeable.
No, he's not, he does not.
Agreeable for decree on compromise. You do one
If
thing.
the terms are worked out. The terms have to be worked out.
The terms is you are entitled as per your claim to 190, which is 5 lesser, which he's give it. But that has to be partition that will go out there before the revenue authority. So this can happen. And the second is you can only ask for development agreement. He's going to cancel and give it. Matter over. And the general power of attorney, you have no business out
I
there.
know.
Matter over.
Others have.
This
they have
is the
given.
simple matter.
Actually, my submission is that what he wants to get on 5.5 lessons of land, if he get today and after winning the land, after 10 years, he will get such amount of land. Not beyond, he will not get the beyond that. So why he has objecting, I don't know. Suppose he is claiming.
Because he
5.5
retired
lessons
from
of land,
Reserve
he
Bank.
will get today. But why he is fighting
Ah.
and that will get
It's
after
okay,
10
okay,
years.
okay. We'll have it some other day now. In the meantime, you take, yeah. Also list this matter again on. List this matter again on 14th of May, 2025. This court observes that the interim order passed on 19 to 2025 shall continue till the next date. It is however observed that in spite of the interim order by which the further proceedings of title suit number 777 of the 2023 have been stayed, the parties to the suit are still at liberty to file a compromise petition under Order 23, Rule 13 of the Code of 13. 13?
My
No,
lord, there
no,
is
no,
a
no.
problem. They will get or raise objection regarding the point of compromise. That is-
Mr. Bora, I'm giving you a liberty. Whether you do or not, I'm not here. I'm only asking you. I have liberty to file compromise petition before the learned trial court, if so advised.
That may be on the 30 April within that period.
Not possible. I'm giving you more time. 14,
23 rule 3, not 1. Order 23 rule 3.
Rule 3.
40.
1 3 is liberty. Liberty. Yes,
Other side
what
is
is
here.
this?
Lord, I am preparing for this one as well. Yes. Lord,
This is the
yesterday
case
I
in
got
Lordship. We are challenging the order of the family court, my lordship, with regard to interim maintenance granted by the family court.
Today we have filed Okalotama. Yesterday I got the papers.
When?
Yesterday I got the papers and today I have filed Okalotama.
Mr. So-and-so appears on behalf of the respondent, taking into account above this matter on 7th of May.
Lordship, I have been coming from Delhi.
From?
From Delhi.
Very good. Delhi would be very warm in the month of May. It is very good weather out here. Come more often.
Almost same, my lord. I have formerly in Assam also.
You can very well appear through the video conferencing. You think-
Second of May, my lord.
Not 2nd of May, 2nd of May not possible. Okay, 2nd of May, 2025.
Public, 41.
May I please tell us?
Hmm.
Francis have already served an affidavit filed also.
Hmm.
26/3/25, regard not received back plus. And Indian process. Respondent number,
Pay the justice service.
what is the page number, let's see. 94, let's see. Affidavit filed.
How many persons were there?
One, sole respondent. Wife of the place,
Yeah, Alpana Gogoi Pathak.
let's see.
This court duly takes note of that the service upon the this court duly takes note of the affidavit of service. So filed on 18th of March 2025. From a perusal of the said affidavit of service, it is apparent that the service upon the petitioner, respondent is duly complete, have been duly effected. Considering the above, this court deems that the service upon the respondent is complete. However, as none has appeared, this court for the ends of justice fixes this matter again on 19th of May 2025. Interim order passed earlier shall continue till then.
42.
For admission, huh? Hmm.
The justice service has not been accepted. And
Service done.
report on registered step and usual process.
What has happened? None has appeared.
None has appeared.
I've given a stay, no.
No.
When is the next date fixed? Next date fixed before the.
Yeah. Has been kept in abeyance.
You see, this court have duly taken note of the affidavit of service filed by the petitioner. And from the perusal of the said affidavit in service, it is seen that the service have been effected upon the respondent. Respondent or respondents?
One.
Respondent.
Number one.
Upon the respondent number one. Accordingly, this court deems service upon the respondent number one to be complete. However, as none has appeared on behalf of the respondent number one, this court for the ends of justice adjourns the matter to be listed again on 19th of May 2025. The intake, this court in 25. It is observed that if on the next day the respondent number one is not present, this court shall proceed with the disposal of the suit in the absence of the respondent number one. This court, in addition to that, taking into account the observations were made, taking into account the materials on record, this court is of the opinion that till the next date, the further proceedings of title suit number 73/2022 is required to be stayed pending before the court of the learned civil judge, junior division number 1 for child is required to be stayed. Else, it would cause irreparable injury to the prejudice to the petitioner. So accordingly, so and so. Order dated accordingly, the further proceedings of title suit number so and so pending before the so and so is stayed till the next day.
43.
In this case, the return report of the service matter today we have received, we need to file an entry.
Then
By Tuesday we will file.
affidavit of service filed,
Today we have received it.
you have not
Right.
filed it.
Not filed. We have received just today.
We've seen that steps have been taken by way of registered as well as usual, but the affidavit of service is yet to be filed. Taking into account the above, this matter again on 28th of May 2025. The interim order passed on 12/3/2025 shall continue till then. The registry shall give an update as regards the service upon the respondents.
Wait, it's a lot.
40?
No, this is a. My IA has been filed, but without serving copy to us, my lord. My lord,
The Sigurd submits that the, what is this I for?
my lord, if I may submit on the entire issue. CRP, my lord, is revolved around only limited issue, my lord. CRP regarding, my lord, rejection of an amendment prayer, my lord. Rejection of an amendment prayer made by the plaintiff. Against that, limited issue, I may submit, my lord. But, let me, my lord, in another date, my lord, for disposal.
Copy, give a copy
Copies
to me.
regarding
The so and so's. It does the learning council appearing on behalf of the petitioner that serve a copy of the interlocutory application to Mr. Yasuda. List the matter again on 4th of April 2025. Copy.
My
give it
lord,
to the-
instead of 4th of April, my lord, any other date, well, I have some difficulty. my
Okay,
lord.
9th of April.
File. Hello.
45.
Lordship, I has been filed by the payment for withdrawal of the amount deposited by us.
You have filed.
Has been filed by the claimant. We are the appellant in the main case. Your Lordship.
Where are they?
We are the claimants, Your Lordship.
What is your ground?
Lordship, we are challenging the quantum, Your Lordship, regarding withdrawal. We have no objection.
This is an application seeking withdrawal of the amount of 50% deposited by the appellant insurance company pursuant to the order passed by this court on 24/11/2021 in IA Civil 1976/2021. Taking into account the materials, taking into the grounds stated in the application. The application stands allowed and the applicant is given the liberty to appellant stands allowed, full stop. The appellant is directed to file an application before the registry of this court And the registry of this court shall, upon making proper verification, identification, and upon furnishing of the bank details, release the said amount so deposited in favor of the applicant. I extensive service.
The main appeal, your lordship, service is completed and LCR has been received, your lordship, so it may be issued on the-
Appeal. Service is complete and they are having been received, list the matter for hearing in the usual course, liberty given to both the parties to file application.
46.
Yes, you did not go. You are not supposed to be here today. Remember, didn't you tell me? 28th, you won't be here.
I was, in fact, I went there. But case was not taken up.
See? What objection you have? Release, na?
It is, yes.
Who are you? Who are you? You're the appellant. What is your objection?
There is no objection as such.
Yeah, same order. Allowed. Same order. Allowed.
There also I'm paying complete question of the audit or people into the insurance.
Well, my lord, basic ground of appeal is, my lord, if there was no, my lord, involvement of the truck. The charge sheet also indicates that, my lord, because the truck overtook the Maruti vehicle and the driver of the Maruti vehicle, my lord, he turned his vehicle towards the front and but there is no connection to the
You're the truck.
and the accident, my lord, alleged accident had occurred at 4 o'clock in the morning. There is no eyewitness examined by the check. The owner and driver had filed a written statement. They did not even admit that the accident had occurred. Not in the dock.
Lordship,
Initially, the case was tried under section 302 of IPC. Thereafter, suddenly, after a month or so, one lord appeared and said that truck had overtaken, and because of overtaking of the truck, the Maruti vehicle had like turned towards the left and vehicle was in the front.
Vehicle was yours.
Yes.
Own vehicle.
I'm the driver of the vehicle
There are
of
two cases.
Alto car.
Huh?
And I am the driver of the Alto car.
Of
And Alto car. And the vehicle, the truck was while crossing or overtaking the Alto car, suddenly moved left. And in order to in order to
How did you prove it?
the charge sheet is there, Lordship.
How did the
And-
charge sheet happen? Charge sheet.
That is,
State-
Charge sheet was there, but there is, charge sheet indicates that there was no connect between the truck and the other truck. Simply on the statements made by one of the witnesses who appeared after the mark. Charge sheet was filed.
No, I understood, but then also there's some official piece of evidence. There's some official piece of evidence.
Yes. Certainly.
Did you cross-examine the witness, the police?
That was not put on the document, that the charge sheet was,
Charge sheet was not proved,
charge sheet was proved
by the claimant.
by the claimant,
was proved.
Lordship. And Lordship, moreover, they took the plea of contributing negligence. If the truck was not involved, then what is the question of contributing negligence? And moreover, the driver owner in their joint written statement stated that the truck was involved in the accident.
Nowhere. The written
Lordship.
statement copy is with me. The 2-page written statement filed, they simply deny the all the claims of the claimant. Written statement of the- Well, It's a case where, my lord, some amount of, my lord, investigation is required. The joint written statement filed by the owner and the driver.
Paragraph 7 and 8.
And these two persons did not come for evidence.
No. And my lord, yes, basically we had examined the defense witness, my lord, who stated that
So your case is of fraud.
allegedly fraud, my lord, but that was not, in fact, my opportunity was not treated before the tribunal. We simply said that there is no relation with the accident. And the propriety of the FIR and the charge sheet was also not challenged. So these two things are there, but. my lord,
But the problem arises,
my lord,
just for example, if a car or a vehicle is processed in such a manner even without touching it, it may result in a very bad accident, which may have happened here.
that I understand. Only problem is, my lord, the mother of the deceased, my lord, they were, in fact, what the story web was like this, my lord. In the night at around 12:30 or 1 o'clock, he got a call from someone, unknown person. Both of them left the house. By 1:45, their mobiles were switched off. The next morning, they were found inside the pond. And the mother had filed FIRs alleging that some miscreants have murdered both of them. So the police proceeded accordingly. The first GD was recorded, my lord. And thereafter, my lord, after a month, suddenly one, my lord, witness appears and says that I have seen the accident. The truck had overtaken and the Maruti car, my lord, that.
And what does that was the FIR.
My-
FIR was charge sheeted by saying that there was an accident, not a murder.
Yes. That was finally held. But the charge sheet, my lord, it indicates that there was no connect between the two vehicles.
In the charge sheet, it is said that in order to avoid possible collision, the Maruti Alto moved towards left and fell down in the pond. The truck was overtaking the Maruti car and suddenly moved left.
Who says so?
No one.
In the charge sheet, it is
Now, how is it possible that it moved left? Nobody saw it.
a statement that the
So who has given that statement?
investigator took the statement of
No,
the.
right. Does the investigation from whom? That person said at night.
No,
He was present.
nothing like that.
Worship,
That is just a story which I have been based on. There's a pollution which is.
Lordship,
What I suggest at this stage is, my lord, if my lord pleases, let me take steps on 4 and 5, maybe by substituted manner. Let them be for this honorable court. Then my lord, LCR is also here. There are two appeals, both are admitted. We have deposited the amount. Both the appeals can be, my lord, heard and
Where is
disposed.
the
Lordship,
Other appeal is, my lord, 383 of 2012. That is the owner of the vehicle, both of them were.
Lordship, As per the investigation report.
Yours is IA 906,
906.
no release. The M. Talukdar, hearing on behalf of the petitioner, submits that the amount which have been deposited be released to the petitioner. To the applicant. Mr. R.K. Batra, the learned counsel appearing on behalf of which is the appellant insurance
Appellant.
company, some bids. That the accident on the basis of which the purported accident on the basis of which the claim is made seems to be an afterthought, as would be apparent from the evidence on record. Submits that there was no eyewitness. And the FIR which was filed also was not in respect to any accidents. He however submitted that the charge sheet had opined, in the charge sheet it was opined by the investigating officer, but the same could not have been taken to be a gospel truth. Taking into account the above, it is the opinion of this court that the matter requires to be heard at an early date instead of permitting release of the amount. This court further takes note of that the service upon the respondent number 4 and 5 is yet to be complete. The respondent number 4 and 5 are the owner and the driver. This court have also perused the written statements so filed, wherein in the earlier, wherein the initial stand does not show that there is any accident. However, at paragraph number 7, 8, there is a mention of an accident. However, be that as it may, there is no details also given. Considering the above, this court finds that the service upon the respondent number 4 and 5 is essential for the purpose of deciding is essential. For that view of the matter, it is the opinion of this court that the appeal is required to be disposed of at the early cannot be disposed of by can be disposed of by dispensing the service upon the respondent number 4 and 5. Accordingly, this court directs the appellant insurance company to effect service upon the respondent number 4 and 5 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. This matter on 27th 7th of May 2025 for hearing. Taking into account that the records are already available, the service be completed, the dusty service be effected on or before 19th of May 2025. Is the calling.
And this followed analogous appeal impact. The analogous appeal matter.
The R.K. Batra further submits that there is an analogous appeal of the said appeal being in connection to the same purported accident. The said Actually, the said MSC case number is, appeal number, the appeal number is,
383 of 2000.
registry shall also list the said matter along with the incident.
Obliged.
Very clear, 49. Oh. 50, what is this? What do you want?
Claim for directing the registry of this honorable court to release the deposit ordered amount
Objection?
in favor of the applicant oblique respondent of 2 and 4 lordship, 2 to 4 lordship. Because during the pendency of this appeal lordship, one of the respondent number 1, she died. She is the mother of the present applicant, and they they are the only legal heir in this case, lordship, and they are the party also.
So you have filed an IA for release.
Release, lordship.
Good, I'm allowing it.
Lordship. Much obliged.
And if somebody has died, tell him you do the needful.
Lordship.
You cannot appear. Are you appearing for ghost?
No.
Then? Yes. You are RSA.
What?
You wanted the stay. We continue. Here is it.
Here, my lord,
You're lucky enough today in the last matter also. I was matter as an E9. RSA condition, to IA condition.
277.
I fixed it for hearing.
What?
IA condition. There's no stay given.
here, not my lord, I have filed it for temporary.
Notice was issued only.
Notice issued.
Then?
Notice issued, other side appeared, your lordship on the earlier occasion also specifically observed, my lord, if they do not appear.
একটা কাম করো এই দুইটা ম্যাটার একটু হিয়ারিং পজিশন না অন্য করব ও এইটু কেস টু দেখব আইএ করে দিব এইটু আরএসএ তো দেখব হ্যাঁ আইএ তো দিব লিস্ট দ্য ম্যাটার এগেইন অন 4th of April 2000
My lord, what, on 8th,
8th of April 2000
I'm obliged.
এইটু না লাগে মানে এইটু হিয়ারিং কমপ্লিট ইয়ার দিব না
Obliged.
Yes, Mr.
Item 45, I was in court number 9, my lord. Kindly
40?
release of the amount, my lord.
I've allowed it.
Is it true? Release of the amount 50%.
45 I allowed it. Somebody appeared, I suppose, but anyway, 45 allow karo na. Allow. You want to put your name, I can put your name. Yeah, yes. Okay, see you after briefing.